Welcome back. Alright, it is late at night. I already know this is going to take me a few days to get through, but we had a new hearing. From what all the comments and what I'm seeing, everyone says a lot of stuff goes down and it gets pretty spicy, so I'm excited for that. And in this hearing, Miss Sarah Catherine Paulson has not one, not two, but three attorneys with her. She has the three blind mice backing her up, searching their way through the dark, trying to find a defense, and it's nowhere to be found. And I have taken the note that I may apologize too much. And I'm sorry. Nope, I was just I was just about to apologize for that. That's just a thing that I need to work on. So, for this video, from now on, for the rest of this video, there will be no apologies. I can't guarantee that for future videos, but we will get there. So, I'm going to do what I'm going to do, and it's going to be what it's going to be. So, let's see what Alvin and the Chipmunks can do, and jump right into it.
We're here this afternoon on a litany of hearings. The court did receive the state's response to the motion to return property, which just filed yesterday, and the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right, any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my two assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all.
So she has even more lawyers or more legal resources. She has 5 people now. You know what? In her letters in the past, she has talked about her defense team. Back when it was just her and Mr. Billy Lane, but I was wrong. Look at me. I made fun of her being like, oh, you have a team of 2. Look at me over here now. Egg on my face. She has a literal defense team. 3 lawyers, these 2 other people assisting in some way. Maybe they're lawyers, maybe they're paralegals, I'm not sure. And she's surrounded by them. What world are we in? We went from her just ripping through attorneys. And yes, we are all clear. I guess I have to make it clear on every video. And maybe I should, just in case this is your first time ever seeing me. But yes, we are aware. She had 8 lawyers appointed to her. She herself only chased away 4 attorneys. But we can repeat that. She chased away 4 attorneys. And she ended up on top. Look at this. America, take notes. This is how you too can get 3 lawyers to, I guess, practically shut down their own practices, because they said they're going to have to put all their other clients on pause to focus on this. What? We're like 2 weeks away from trial? Wow. I don't feel bad for any of them involved. You can embarrass yourselves all you want. Go for it.
Anything else, sir?
No.
Okay. To the extent we may be hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion the defendant's motion for statement of particulars. That was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill Jorge Torres. Judge, that's about as bare bones of an information as you can file in a case.
Exactly. So you agree. This case is nothing special. It is so simple, it can be summed up in just that. It absolutely is that. They gave you when it happened. It was an imminently dangerous act. Are you going to say zipping another human being in a suitcase is not an imminently dangerous act? Or do you not understand or make that connection? And showed a depraved mind, which if you watch the video, that is more than enough confirmation. What else more could you want? I don't know. Me personally, I just have no idea what they gain from making the state elaborate on the obvious. Like, what more do you want them to tell you?
You know, anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language.
But there wasn't a weapon used. Do you want them to say that she killed him by way of suitcase? Using a suitcase as a weapon? No. Unless you want them to bring in the bat. But then you would have to admit that the bat is a part of this. I get he's new to this and he's trying to work with what he has, but what he has is a sinking ship, and I think he's finally getting it. He's finally getting that the other lawyers had no chance either, and that you're going to do the best with what you have, but you're going to be making a lot of reaches this entire hearing. I can already tell.
That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres.
Okay, so you're saying that because they didn't say by an act imminently dangerous, comma, zipping Jorge Torres in a suitcase, filming him, laughing at him, then going upstairs and going to sleep, as the act that was imminently dangerous, which caused the death of Jorge Torres. You want them to just write that out? You can watch the video and gain that. There's your context clues. Having them write it out in a formal way does nothing to help you. You just need the knowledge, not that they officially wrote it down for you. Because yeah, you can say that the language is vague or whatever, but that would probably work better in your favor. That way you can tailor it a little more to your side. But if you get them to lay out the literal facts that are exactly reflected in those videos, it's not going to look good. So you'll trap yourself even more down the line. But whatever. You really, for some reason, want them to write these words down. So, make your case.
This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out.
So you just admitted the particulars of the case. You just summarized the particulars of the case. You know what the particulars of the case are. What is the purpose of having them write this down? Maybe there's something. Maybe he'll explain it. I don't see it right now. But you just summarized this whole case. So you know what it's about. Why do you need them to say what you already know?
By Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose.
Oh, okay, I see. You don't actually want to know the facts of the case. You want the prosecution to lay out their arguments. You want to hear how they summarize the case, how they are going to present the case so that you can find specific points to counteract instead of just the general. Here are the general facts of the case. It's kind of obvious to put it together, but I don't know how the prosecution is going to present that. I don't think they have to give you that. I don't think they have to give you that. That would be really weird to me. You have to provide a statement of particulars in order to run certain defenses, but the state doesn't have to give you a statement of particulars for the charges. They just have to be clear enough for you to be able to put it all together. And then you come up with defenses for every possible outcome. The state's not going to tell you everything that they have or their approach to the case. It's there.
None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres?
What? Are you kidding me right now? Are you serious? Did you not see the videos? What do you want them to write down? She exhibited a depraved mind when she took out her phone and created a video, 2 videos. And on the video, she is heard saying, "This is for everything you've done to me. This is for everything you've done to me. Fuck you." And then when he's heard on video saying, Sarah, I can't breathe," and she says, "That's my name, don't wear it out," not only did she confirm that it was her voice in the video, but that she heard him say it. That she heard him say it multiple times. She acknowledged the message that he was conveying. So she can't get up here now saying, "I didn't know what he was saying. I didn't know what he wanted." You knew exactly what he was saying. You were telling him to shh, because that was his issue. You were telling him that if you can't breathe, then maybe you should shut the fuck up and conserve your oxygen. You want to say that she didn't have ill will saying those things? Are you kidding me? You want them to embarrass your ass before trial even starts again? Oh gosh, this is going to make me upset. I get it. He has to try to do stuff like that. I do. And so I don't fault him as a person, but as the lawyer in this courtroom representing who he's representing, I will critique him how I critique him.
And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged.
And there you go. Everything that you mentioned were the essential facts of the case. You want to know the hyper-specific facts of the case, but those are not the ones that are essential to you making a defense. You don't need to know anything else than the date, time that he was killed by an act committed by her. Here's these videos. Here's the evidence. I think you can put two and two together. There's no other surprise there unless they bring out a magic third video. Yeah, this is grasping at straws.
In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Judge, the state stands by its written response
Yay, it's Mr. J. I'm expecting the spice now.
that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial.
Exactly. Because back when she was representing herself, they tried to make it as simple as possible. They gave her a lot of help and made things super clear and tried to adjust to her. She was given this information by the state. So just because you decided to hop on this merry-go-round of mayhem at the last second does not mean that the state has to redo the things that it already did. They don't have to redo it for you if they've already done it for the defense.
And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out.
I'm glad he added begging, and I hope he continues to stress that.
And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder.
It absolutely could not be clearer on that video. And I was debating showing this or not. So maybe this might be a test run. This might be a little controversial. But I actually isolated Sarah's voice from that video and tried to cut out as much of George as possible because I don't believe he should be remembered or memorialized by his last recorded words. But I do believe she should be chained by her words because they are horrific. So I'm going to count down from 3 and just like skip ahead. It's probably going to be like 15 seconds. It is just her voice and not the video shown. I have Law and Crime's logo over it, so don't worry about that. And yeah, I might cut this out. I might leave it in. I'm not sure. But yeah, did she have the mens rea of a depraved heart or not? In 3, 2, 1.
For everything you've done to me. For everything you've done to me. Fuck you. Fuck you. Stupid. That's my name. Don't wear it out. Yeah, that's when you do when you choke me. That's on you. It's on you. Real or ransom. I want to get video for it extra. Because I got this. Real or ransom. Oh. That's what Chingo mean. Fuck you! Yeah. You should probably shut the fuck up. Shh.
Okay, so I am a liar. I am going to apologize for that. So I do apologize if that was activating for anyone, but I felt that it was important just to put her words out there of, how dare you say, what proof do they have that she had a depraved heart at that moment with ill intent and a total disregard for his human life? She answered every single one of his pleas with a horrifying way to say no, with an insult, with a taunt. And you're saying because the prosecution didn't write that out word for word, that you have no idea what to expect at trial? Nah.
So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
That was great, Mr. J. Nice, concise, saying there's nothing special or unique about this case that requires any more specifications. There aren't multiple parts or variables to this crime. And just because it's been a few years doesn't mean that she's entitled to a statement of particulars. So he covered both bases really well, in my opinion.
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And
Not a great opening to the response. Not you completely abandoning critiquing his argument or points, not saying you have your own arguments. Your opening statement is saying, I know he made a great argument over there, but you, judge, have the ability to require it. So he's putting the onus on the judge. I'm not going to really argue it properly because I don't really have a good argument to counteract what Mr. J just laid down. So I'm going to plead to you, judge, saying you can ignore what he said and require him to give it to me anyway, even if I can't give you a good argument. Okay.
This is somewhat of a unique case, and he mentioned, the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death.
Yeah, we know. I'm just shocked you're already admitting it. I mean, I get it. It's like what we brought up earlier. You want the state to detail what they think happened. You want them to say, she must have used the bat to knock him out, causing that big lump, and then pushed him down the stairs, and all of these other injuries showed up that way. Unless he like hit his head at the bottom of the stairs just with how the suitcase landed, and then that could also explain the bump in there. And yeah, that didn't cause death, but it was a part of the series of acts that led up to it. And you want them to tell you exactly what they think happened, whether they think it was the bat, whether they think it was thrown down the steps, because no one's really talked about that. No, I'm trying to think. We know about that, and we talk about it constantly, like online, but I don't think anyone legally has suggested that she threw the suitcase down the steps yet. Interesting. So I guess they also want them to either detail that or the bat. And no, they don't have to do that, because then you would just want to focus on those details and try to develop defenses disproving those aspects, when you should just prepare for all of it.
And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres' death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is...
But is there anything that's missing under the statute?
Thank you, Judge Kranick. Someone needed the objection narrative, because where were we going with this? Good grief. You're supposed to be responding to what the state brought up, not let's just go in this colloquy of what is going to happen, what are the hypotheticals, are they actually going to bring in his other injuries when talking about the cause of death, or just the specific cause of death? Sir, I don't know how many murder trials you've done, but I'm pretty sure it's probably been a lot. When have they ever omitted other injuries on the body when discussing the cause of death in any case? Even if it's just to address it to say it doesn't matter, when have they not included it as an important part of the case in order to either dismiss it and show the jury which part to focus on, or if it's to highlight it, to say this also led to it? Why? Because her defense is that he could have gotten out himself because he had 2 wiggly fingers, but if he had been drinking all night with you, and he had also been hit in the head and pushed down a flight of stairs, how could he think of up and down, side to side, wherever he was? In the dark. Sensory deprivation. Just another torturous element to this. I don't know where I was going with that, but he didn't know where he was going with his story either. So thank you for cutting in, Kranick.
I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
Okay, what are we doing here? Mr. J just gave you examples, as in if the murder occurred over a period of time where there were multiple incidences, where you beat someone up, you leave, you come back, you leave, you come back again. And then if all of those counts listed as battery, you would need a statement of particulars to discern what you're talking about and when. There aren't multiple elements in this case. It is very chronological and simple to understand. Well, no, it is not simple to understand, but it is clear to see.
But the date's there. The time's there. Where it happened is there. The underlying charge is there.
I
What's
understand,
missing?
and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that.
Everything you're bringing up is just making this all look worse. Yeah, those are all questions we have because this crime is horrific. Yikes.
The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law, based on the unique set of facts, that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And, of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior and what exactly they're claiming that she did.
So you are asking the judge to come up with the arguments for you. Instead of you saying, I need these additional statements because of blank, 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 or I can't find this information because of why, you're just putting it in the hands of Kranek, saying, technically, you could just force them to give it to us. You could do that. So it's your job. You could do that, so you should, without actually making an argument of, you need to do this because blank. You bringing up this blunt force trauma is not going to work out in your favor. You asking for their theory of the case, they don't have to tell you their theory of the case. They just have to provide you with the facts that make it a level playing field. You have all of the discovery. You have the affidavits, you have the reports, you have the interviews, you have the 9+ statements that she made to other law enforcement and officials at the scene of the crime. And, oh, that's right, you have your client, the person who was there. Ask her for a statement of particulars.
That constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video.
You're saying that as if the video is not the only evidence that needs to be shown to prove this happened. That is the most damaging thing ever. You're like, are they really going to charge her with second-degree depraved heart murder just because she filmed it? Okay, there has to be other things. There's stuff that happened before then and after then. You're right. And it makes your client look even more guilty. Let's bring in the neighbors who said they heard them yelling all night. Let's bring in the brother who said they started yelling at 7:30 a.m. Not a.m., whoops, at 7:30 p.m. And how that continued all the rest of the night until the neighbors say around 10:30 it got real quiet. Until they heard a humongous crash and bang that shook their whole wall at around 11:15 by their estimates. And it just so happens that the video was taken at 11:12. So we have an idea of what happened beforehand. And it was not the pleasant day that she originally stated. But now you're stating that it wasn't a pleasant day. So how do you think this is going to go over? Are you going to tell the jury, I know you're about to hear all this evidence. I want you to know my client is a liar. Liar. But that does not mean she's guilty of second-degree murder. Just because she lied to everyone's face since the moment she's called the police, actually since the moment she called Brian, does not make her a killer. Now, don't look at the video.
That's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912.
Translation? No. Denied.
It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Which we knew that. We knew that was going to happen. This is not one of the major ones. This should have been the easiest one on the docket, and now we get into the more nitty-gritty, blah, 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 blah. However, what I thought was interesting was Kranick saying that receiving other notices or filings from prior lawyers denying the charges. To me, that goes in direct contradiction with this new defense, which isn't denying the charges. It's just saying that it's justified through self-defense. So for all these years, you've been denying it. And now that we are literally a month away from trial, I mean, we're not anymore. We're only a few weeks. But when you jumped on, we were only a month from trial. You did a whole 360. Now it was intentional. And it was self-defense against someone who was injured and caged.
Moving now to, give me a moment, and I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020.
He wants these procedures in order to try and keep out the interrogation, because the interrogation film is his biggest problem in all of this, pretty much. You could probably argue away the video, you can argue away all these things, but what she did in that interrogation video unravels any defense that you can come up with. So you have to try anything you can do to get rid of that statement. It's not going to work, and it's 100% going to come in. But he's got to try, I guess.
And then the second motion for additional discovery Specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation.
And they want the Miranda card in order to say she wasn't Mirandized, so that way she didn't know what she was doing and da-da-da-da-da-da. But we all heard it. She was sworn in multiple times, and then she was sworn in at the end of them as well to confirm, was everything you told us today true and accurate to the best of your knowledge? And she said she understood every single time. So good luck with that one.
Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office, and we did make a request to the Orange County Sheriff's Department back on September the 10th, and the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but
We have official confirmation. I've been saying this since the beginning because Sarah keeps bringing up in all of these letters, I know everyone has seen the video. How much shareable income have you all made off of it? Now that it has 3 million, 30 plus million views, this, da, 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 da. I'm like, yeah, judges are busy. It is very easy for them not to look at evidence. So no, he did not view the interrogation. He's never seen the interrogation. Once he sees the interrogation, it is a wrap for you. Everything, all the vibes that he's been getting and everything that he's already been cueing into is going to be 100% explained and just put on full display of, oh, you're that girl I thought you were.
okay, the day after this event,
Killing, but okay, we'll go with event.
she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were.
All right, take it easy. They absolutely were read. And no, she was not coerced. She didn't even have to show up at the police station. She did it of her own free will. That's why in the interrogation, she said she opens the whole thing up with saying, "Thank you for coming in." As in, you did it. We did not bring you here.
Appreciate you coming in. Yes, ma'am. And I want to ask you about these whenever we have a moment. Sure.
She came in with her own list of questions, meaning she had the intentional free will and desire to ask questions and have a conversation with the police. And once she showed up there, she was in police custody, meaning if you are in police custody and you want to be questioned, you have to be Mirandized and made aware of your rights. All of these things happen. Nothing about that was coerced.
I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda.
She was in a police station. 90% of the officers have a gun in that police station. So it's not like he was the only armed person surrounding her, because there was definitely police officers outside of that interrogation room. So no, I don't buy that. And yeah, she didn't, but the thing is, she didn't know she couldn't leave that room when she was in there. She never tried to. She wanted to be in there to ask questions in order to convince them to be on her side, because that's what she does. She tells people her side of the story, and because she's so used to saying the quote-unquote right words, it's worked out for her. and she's played into the stereotypes that have always worked all her life, and by telling her story, that is supposed to be enough. So she did what she always does, and she voluntarily showed up to try to paint her side of the story, and everything fell apart, and it didn't work out for her. And now she wants to act like, oh, I didn't know what I was doing, and they forced me into giving some of the worst answers imaginable to the very simple questions that were asked of me.
I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information.
Why aren't you telling us the question? Because she absolutely did read off the card, and I don't think she maliciously was like, ooh, I need to trick this mastermind of a criminal by omitting this last mystery question. So what is it? Because I remember seeing her. She read it straight off the card.
Make sure it's verified before you file, in good faith, a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting.
You keep bringing up he denied your motion for continuance like that means something. Normally that means something if you bring up a motion, Judge, you denied this thing when I was trying to do the right thing, and because you denied it, I can't do the right thing anymore. However, you knew he 100% was going to deny it because he told you he would. So that doesn't work here. You don't get to say, you denied the motion that you told me you would deny, so now I can't do the thing because I knew you were going to deny it before I even agreed to sign on. That's why I waited weeks to join, because I was, quote, waiting for someone else to pick up the torch. Okay.
I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Do you know how weak your argument has to be if you can't even put a motion together without one sentence at the end of a Miranda standard card? That they almost all sound the exact same, maybe with a fluctuation here or there, which should tell you if not all of them have that same policy or that same last question, whatever mystery question you're talking about, then it probably doesn't go against the Constitution. And it probably doesn't mean she missed any of her actual rights. You know what? We're going to stop. We're going to listen. What did she actually say?
I want to see the receipts.
So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay.
Sounds like she covered all her bases to me. She even put on the record, remember what I read to you yesterday? Remember, these are the same rights that I already made you aware of and you confirmed, so I'm going to make you aware of them again. And she said, do you have the right to remain silent? Anything you say can and will be used against you. You have a right to an attorney. If you can't afford an attorney, one can be provided for you before and during questioning without charge. Did anyone threaten or promise you anything to get you to speak with me? And do you understand what I just read to you? She said yes to all of that. I mean, in the video, you see that she's taken a sip of water, so maybe she should have been paying attention if it meant that much to her. But she said she understood. In that last question of, well, before the understanding question was did anyone threaten or promise you anything to get you to talk to me? That is a question of coercion. Are you being coerced to speak to me right now? If your answer is no, that means you are speaking to me of your own free will. Do you feel threatened right now? Do you feel like anyone is promising you anything? No. The only thing that he can hold on to is when she said, so we got the report, and obviously since we got the autopsy, we have to talk about that, so I have to read you the rights. And he's probably going to hold on to that. We have to talk about that. And so technically, no, you don't, but also you do-ish. You don't have to talk about it, but the moment you step foot in that police station, you weren't leaving. So it was either we have to talk about this now or the cuffs come on. So that's the context of it. Not saying you have to say anything to me. It's you don't get to just leave anymore. It's either we talk about this now or you go to a cell and we can talk about it later. That's how I read that. But now he's going to say that she is saying you have to speak to me, even though I just told you you have the right to remain silent and you said I understand.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months.
Exactly. Thank you. Yes, Mr. Owens is up here acting like this is my first day on the job. It pretty much is. So you have to give me all this time to train, learn. Nope. Like we've said this whole time. And you kind of have to go through this so you train him. So you instill it in him that we told you, you being new does not change things. It does not give you special treatment. If we've done it for the defense, we've done it for the defense. And you're still coming up here with this, I just showed up, please be nice to me, we haven't gotten nothing. And they're like, yes, you have. Sarah Paulson has had these things. Sarah Paulson has had the option to take this route before, and she hasn't. Or she hasn't let her lawyers go this route. We know Bankowitz wanted to go this route. And we know maybe other people looked into going to this route, and she said she didn't agree with any of them. Now, she says she does agree with them. And I understand that she has to. She doesn't have a choice. She has to come up with a defense of some kind. This can loosely be strung together because she got rid of every other defense. And they know how damaging that interrogation video is. However, she was given every warning, opportunity, and chance to not say anything whatsoever. And she did it again and again and again and again. And now you're upset about that and you want to point the fingers. No one forced her to do this. They tell her up front what she tells us now will be used against her. And now it's about to be used against her and she wants to call foul.
Now, turning to the merits of this. They are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is Statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing.
Exactly. It honestly just reveals how desperate they are. And, good for them for finding something they could latch onto. Because that means they had to scour through everything. And the strongest argument that they could come up with was maybe she didn't get Mirandized properly. So we can throw the whole thing out. Forget all of the times she gave consent, all the times she didn't have to speak. Because for like a good hour there, they stopped asking her questions, and she kept asking them questions again and again and again, reinitiating the interrogation once they stopped questioning. So, I get it, you're trying, but no, there's no merits to this, and I don't feel bad about you losing this motion.
What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law.
Oh, 100%. Every lawyer or every new lawyer's first thought as soon as they saw that interrogation was, how can we get this thrown out? And not a single one ever thought they could. Mr. Owens does have to try, but if it could have been done, it would have been.
And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial, because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either.
And that is honestly a great point of just because the state could, in theory, do it, one, that's not proven fact that they could, but just because they could doesn't mean they should or have to. They are asking for discovery from a third party, meaning the Orange County Corrections, Sheriff's Department, whatever, asking the police department themselves for their policies. And they're saying that just because the state could get those policies quicker and easier, that the state could get us this card tomorrow. Okay, and I'm so over this kind of, and I've seen this so many times with little stuff like this. Well, why don't you just give it to her? Why don't you just get it over with and just get her what she wants? This whole thing would go way quicker if you just gave her what you want. No, it wouldn't. You want to know why? Because we've done this with everything. There's been so many things that they have gone out of their way to make sure she has, and it's never enough. There's always something else to ask. You have to set a firm boundary somewhere. It's one thing if you gave her something, she used it properly, and then something else came up. It is always what you give her is never enough. It's never correct. If you had gotten her this card, they would have said, for some reason, this is the wrong card, and why they didn't bring it laminated, and why they didn't bring the actual card that has Chelsea's fingerprints on it. You know, like there would always be something. And you can't downplay it, even if it's something little like this. If you don't have to do it again and again and again, and they can stand up on their own 2 feet like toddlers and walk over to the counter and get that card themselves, then they need to go do that. Because this behavior is learned behavior at this point. They have learned that as long as they throw their hands in the air and say, well, I can't do it, someone needs to help me, someone needs to help me, then they're going to be thrown a bone. They're going to be given exactly what they want, and people will say, well, good, finally they have it, and it'll be good. No, it's the if you give a mouse a cookie, she asks for more and more and more. She begged for that discovery so long. They got it to her in a digital copy so that it complied with all of the prison rules and obligations. Wasn't good enough. Now she wants the hard copies, and she protested and protested and protested until she got those hard copies. They broke all the rules and procedures that they normally have to get her specifically these hard copies just because she complained and said it was unfair. They gave it to her. Wasn't good enough. She couldn't store it like they told her that she couldn't. It was all a mess because the staples and the paper clips and all the sorting materials had been taken away, so it was just free-form paper. Now they can't find anything in it and are making these additional discovery requests for things they already have. But because Mr. Owens is new, and I'm glad they brought up, this is not Mr. Owens' trial, this is Sarah Boone's trial. She has been given this multiple times. And yet she still asks for more because she had the hard copy boxes, the literal boxes that were a fire hazard that she couldn't have, right next to her bunk, as if that is not the biggest security and confidentiality risk imaginable, right next to you. The person who sleeps right next to you could literally just stretch their arms from yawning and knock into your boxes. And then she had the audacity to argue in a hearing that she should be allowed to hold on to the USB drive at her bunk as well. Not only her paper discovery, which is not secure, but she wanted the digital discovery. You know, the digital discovery that she protested against and didn't like at all. And that the laptop that she requested, it wasn't good enough. And that she needed internet with the laptop, and that she needed a Word document with the laptop. So anything you give her, there's always more. And when they said that she couldn't have the USB drive because that's a security risk and they already have it taken care of, she said, well, if I'm already allowed to have the boxes with me, I don't see why I can't have the USB drives with me as well.
Yes. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear other than those reasons why I cannot have those as well.
And that's what I'm talking about. As soon as you keep giving her something extra, she uses that something extra to get more and more. And if you don't give it to her after already giving her all of these other special requests that no one else gets, then you're in trouble. It's your fault because you are hindering her quote unquote nebulous progress. Because you aren't giving what she is calling the most simple thing in the world that never ends in one request. So I'm with Mr. J on this one. Even if it seems stupid, even if he has the Miranda card in his suit pocket right now, they need to get it for themselves if they can get it for themselves. And I don't feel bad about that, not one bit. Why? Because it's the Miranda card. Everyone knows what's on it. It's pretty much the standard across the board, and you're reaching for straws and trying to make it my problem that I should move my schedule around to make sure you get this useless thing. I mean, it's not useless, whatever you're trying to make, whatever argument you're trying to make, but in the grand scheme, this is not a priority. If there's stuff that you need, then we'll make sure it happens. She did need the discovery. She asked for it horribly and was very rude about it, and then didn't know what to do with it, and then didn't even read it all. She had it for all that time after complaining for years and still didn't read it. And to this day, Mr. Owens hasn't gotten through it all either. Him and his 3 musketeers haven't gotten through it all. And yet they still want more discovery. And they're asking for more and more things repeatedly, even though everyone is saying, you have this. Well, we can't find it. Okay, how is that my problem? I've said this in the past. There are you problems and there are me problems. You are trying to make you a me problem, and we're not doing that here. You have your problems because you put yourself in this position. So I'm so tired, even if it's this little itty bitty thing, if you can do it for yourself, do it. And Sarah's never had to do that her whole life. Well, that's not fair. But the life that we have been able to observe from her, that has been recorded, detailed, arrest records, body cam footage, everything, she's never had to be accountable for doing anything herself. She can always call someone in to do something extra, and it's never enough. I still won't get over that November 4th body cam footage that we just covered, where she goes through the whole night lying, right? She lies about being hit because she skips over being hit twice in retellings, and the only thing she talks about is how he was mean to her. And so they spend all night looking for him, getting him out, talking in circular reasoning with Sarah, trying to get a story that doesn't make sense. She finally lands on one. Still doesn't make sense, but it's finally a narrative that she can write down on paper, which she does. And after all of this, all of these officers picking her up, her barefoot ass up from her ex's house, she introduced her son to them, trying to show them off as a prop. And after all of that, and she's finally like, I can finally go in. And she's like, oh, my car keys. I don't know where my car keys are. And they said, George doesn't have them because we did a pat down and put him in the car. It must be inside. She couldn't even walk in her house to look for it. She threw a fit because the police didn't look inside for her keys, find them, and hand them to them.
Wait. I need my car keys.
Okay, they're not on him. They're inside the house somewhere.
You've seen them?
I haven't seen them, but they're in there somewhere. They're not on him because I had to search him before he got in the vehicle.
Is it too much to ask? If you could ask him where they are, please?
Okay,
I only have one set.
Okay. She's asking about her car keys. She said we asked him. Should we ask him where they are?
He doesn't have nothing in his pocket, so they're...
Okay.
Where is she? Huh? No, he didn't have anything in his pocket. We can take pictures real quick, if you don't mind. We're going to take one overall.
He doesn't know where they are.
Man, do you mind?
I need my car keys.
He didn't have anything in his pockets. One dog's sleeping downstairs and one's in your bedroom.
Subdivision coming from the area. No one else seen or heard?
You have any other questions?
My car keys.
I'm sure they're in there somewhere.
So she stood there complaining, whimpering like a hurt puppy of, no one has handed me my car keys, even though I haven't gone inside the house to look for them. It was mind-blowing to me. And this is her exact approach. She's requesting things from people who say she already has it. And that's not enough. Because you didn't hand it to her, she's going to pout and say, where's my Miranda card? Just a petulant child is this whole defense strategy. Let me just throw a huge tantrum and then ask for mercy during sentencing and wondering why you don't see the good person I am inside. Because you use people. You use people. You blame people for your issues. You use them for every little thing you can get out of them. No. I know I've gone on a long diatribe for this one little seemingly minute point, but because it is so minute and small is why I'm so upset at it. Do it yourself.
So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide.
Yeah, but it's only your words saying that she read it improperly. You haven't looked at the cards, so you don't know. You're assuming based off of your prior knowledge of other Miranda cards that you have used. If they have minor differences here and there, that would not shock me as long as you have the 5 main principles that you have to ask and you're made aware of your rights. Then there you go. And she said she understood. She understood she could remain silent. She understood everything could be used against her. She understood she could have a lawyer. She could have had Mr. Owens in the room with her to tell her what's going on. She voluntarily chose no. Why? Because she wanted to plant her seeds. And now she's mad she got caught in the vines. She did this herself. And you really want to call that one statement of her saying, we got the autopsy report back and we have to talk about that, so I need to reread you your rights. And you're taking the statement, we have to talk about that, as a coercive statement that kept her in the room. She kept herself in that room. What is evidenced by it? The first thing she did was bring out a pile of questions saying,
Ma'am, I want to ask you about the incident room. We have a moment.
Sure.
meaning you would like to talk with the detectives and about questions. That is your interrogation. You don't get to choose what questions you can ask and answer in the interrogation. I mean, you can choose what you can answer, but you can't just go into an interrogation with detectives or an interview with detectives, as she would have assumed, and say, I only want to answer my questions and you can't say anything back to me. She could have tried to say that. It wouldn't have worked, but she didn't. She went in there voluntarily to be a part of the conversation, to make statements and to hear answers to her questions. If she didn't want to say anything to anyone, that would make sense. If they put her in a room and said, hey, just wait here, we're going to come get your phone, and then they start answering you a bunch of questions and you didn't want to answer any of these questions, but they keep pressuring you to say, oh, we just have a few quick things to talk about, a few things here, a few things there. No, it was, thank you for coming in. We have to talk about some things. And she said, I would like to get to my questions as well. Now you want to say she was forced to be there. Nah.
Whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here, because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements, because I have unfortunately no frame of reference.
But she says they, number one, the date of this event, they seized her phone at the scene.
They sure did. Voluntarily. She gave verbal and written permission to take her phone because she was trying to play the game of I'm innocent. That's why she also said when they asked, can we go in and do our investigation inside the house? She said, yeah, do whatever you need. It was a murder scene. They were going to get in anyway, but they didn't need a warrant if they got permission from her. So they had a warrant and got verbal permission. She could have said no, put up a little bit of a fight, but no, she handed it over and then directed them to look at stuff on the phone.
She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon.
Now, does anyone actually believe that? Does anyone actually believe that the police, during an ongoing active investigation, where they need to process, image, maintain chain of custody of the evidence in this case, told her that we would be physically coming to return one of the key pieces of evidence back to you the next day. And not only return it, but come to your apartment. This just sounds like something Sarah told them. Like, they told me they were going to bring it back to me and hand it to me. That doesn't make any sense. I don't think police really make house calls to return pivotal evidence to a potential murder suspect, but that could just be me, you know? So yeah, that makes no sense to me. I don't think I've ever heard anyone get their phone back the next day after being potentially seen as a murder suspect. And she knows she has to have been, because she admitted to being the person zipping him in there multiple times. Also, it's just a lie. We know she didn't think they were coming to her apartment to give her her phone the next day. Why? Because she was staying at Brian's. Why? Because she painted his family as vicious murderers coming out to get her, and that she had to run away and flee.
I'm like really scared. I want you guys to know that.
You have all these deputies here, so while we're here, nothing's going to happen to you. Before we go and make any notifications, you'll have plenty of time to leave or do what you need to do.
She said multiple times that she would not be there because she was afraid that his family would find and kill her. So I don't believe that for a second. And neither does Kranick. Look at that face, just as unimpressed as can be, saying, please try to land this plane and let us move on so I can deny this, because this is a mess.
The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone?
Okay, one, I will take that as confirmation that Chelsea was pregnant. I heard rumors, but I hate to assume, and I just was never going to bring that up. But I'm going to assume that he would not make that statement in a courtroom if it didn't have any backing. I mean, he's making a lot of statements that don't have backings, but I feel like that's something that, you don't really just lie about. Anyway, 2, you are saying she called them. And that's how you know it's BS. Her saying, they said they were going to come to me, and then I had to call them to ask them, why didn't you come to me? They did not say that. I can guarantee that. But I do believe this. I'm pregnant. I don't feel like coming out there. Can you come in? But that's not them calling her, telling them to come in. She called them. That means she initiated contact. She drove down there. They didn't call her and say, hey, would you like to come pick up your phone? Not by her retelling. And on top of that, even if they did call you, the police are allowed to lie to you in that situation. They are allowed to lure you into the police department when they know they're going to arrest you. They could arrest you as soon as you touch the parking lot. You didn't have to go there. They would have found you, and they would have came and got you. You made it easier for them. But they are allowed to lie to bring you back in. They could have called her to say, hi, I think your son just wandered into our police department. Do you want to come pick him up? I mean, she would have called Brian and say, can you do it? Because I can't be a mother. I'm just so stressed right now. But if she decided that she did want to be a good mother, she would have been like, okay, cool, I'll come down there. Oh, sorry, your son's not here. You're under arrest. I mean, it's not really the fairest thing or the nicest thing, but it is a thing. So if you go to the police department after a crime, just assume that you might not be walking out. So, before you want to go making statements. Also, can we talk about just a side, unrelated tangent? If you know you're going to the police department after a major crime where deep down you committed the crime, you know that, and you know that you are waiting for them to either arrest you or to say that they've switched directions. Think about what you're going to wear walking in, because that might be the last thing you ever wear. And I see all these interrogations and people look a bum mess. And then they get mad when that bum mess gets plastered all over the internet. You never know when you might be an overnight sensation for some horrific crime that you might commit. Not you, but the general you, that evil person that you know. So when in doubt, show up fresh, clean, and crisp to the police department as if you're never walking out. Because if you're dumb enough to go there yourself after committing a murder, you did it to yourself.
Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, "Is this where I go to get the phone?" He said, No, we got it back here in this room. Come back here in this room and we'll get it.
She saw a desk that had the evidence. She saw like what? The storage locker, the evidence storage locker just on display saying, "Oh, is that where I go get it?" There was a table that said lost and found. Was there a table that said Sarah's phone here? Again, these lies are just so weird. Why lie about something like that? There's not just going to be a desk out there saying returned evidence or returning evidence. Come see here if you are a murder suspect and would like your phone back. Now, I do believe that she asked where she could go to pick up her phone, but I don't think she just saw the table and saw where the phone was. It was going over there, and they redirected her to another room, which also they have every right to do. You're in my house now. How are you going to be walking up and say, I can go here, I can go there? There are few places you can go on your own in a police station, so never assume. Keep telling your story. Keep telling your story.
When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, "Look, we got the autopsy back from the medical examiner. We've got to talk to you about that." 2 times she said, "We must," I don't think it's must, "we've got to talk to you."
That's a lie! That's a lie!
Did y'all hear her say that twice? Because I only heard her say it once, and then she went straight into the Miranda rights.
So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights, your rights? Yeah, so it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
Also, that's the first time I caught at the end, Sarah says, sure. She's acknowledging and giving permission to be read her Miranda rights. And then she says she understands them afterwards. You can only get rid of this if you can prove that she gave these statements unknowingly without consent. And she gave nothing but consent.
She goes, "Okay." So I got to read you these Miranda rights again. And again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly, and she gave a statement.
She sure did. And you're saying she read it incorrectly, and it's only predicated upon the idea that you think that Miranda card says something that you don't know if it says or not. So let's hear what she said the first time.
I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that?
Yes.
Okay. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
Do you understand what I just read you?
Yes.
Okay.
So what about that was unclear? She even stopped after the first question. You have the right to remain silent, and checked in. Do you understand what I said? Yes. Then she continued the rest of them, just how she said it prior, or like the next day, and then got confirmation from there as well. She said she understood it multiple times. But good on you for trying, I guess.
So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, "We've got to talk to you about this autopsy." giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said protocol, because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim.
We literally see her reading them. Yes. I don't get it. You are saying she's lying and you don't even know because you are assuming that there's a question on there that you have not fact checked. And I get it. You want the card to make sure you can fact check it. I don't have an issue with that. I have an issue with you trying to make it the state's problem and making them give it to you. But I get it. You want to see and you want to check. And you might be able to make some kind of argument if that is the case. Right now, you are asserting it as if it is a fact when it is not. And you're saying that she thought they were going to talk about the autopsy. They did. They absolutely did. And the autopsy branched off into her deflecting and coming up with narrative after narrative, and then questions spawned from there. They said, we have the autopsy, here are the injuries. She said, I have no idea what happened. I didn't touch him. They never even asked her, did she do it? Did she give him the injuries? She immediately responded by saying, I didn't touch him.
He had a cut near his lip. We could see his mouth was a little
I haven't laid a hand on him.
Okay.
Also too, he fell off my son's bike.
Okay.
So I don't know, and he's notorious for running into the wall or the hall tree. So
Okay. What about the scratches?
Which opened the door to further questioning of, well, then what happened? Because they were just telling you the injuries. They did not ask you for an explanation. They did not ask you for a cause or if you did them yourselves. You just volunteered that information by saying, I didn't touch them. Okay, my ears are perked. What do you mean about that? What about the scratches? What about this? What about that? And she went on narrative after narrative after narrative, opening up space for question after question after question. So they did start with the autopsy. And because she kept running her mouth, they got into her whole life story.
The constitutional Miranda rights I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video.
Sure do. Sure do. Y'all tell me, am I crazy? Did we not just see the same thing? I feel like I'm being gaslit.
There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial.
That's a lie! That's a lie!
That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
yes,
excuse me.
Oh my gosh, why are you over talking him? This is not that deep for y'all to have an argument over. If the judge is speaking, pipe down.
The arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue? I think that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Damn. Kranik has had it. He is done, and I'm here for it 100%. He is like, if you have the video, the audio to prove that something was unconstitutional, that you want this suppressed, that you want this kicked out, why does this damn Miranda card make any difference? It doesn't. Because if this is an unconstitutional issue, you should have some kind of case law or some argument to back it up to be able to suppress it. Because it's a constitutional issue, not a Miranda policy issue. Right now, you are responding to the state's argument of materiality. You forgot about that because we're in a new dimension right now. But this is how Sarah works. You know, we start one place and then we end up in a completely new world. A whole new world. Okay, anyway. And this is where we're at right now. Kranik is so brilliant. He always knows how to recenter us and bring us right back to where we need to be. You are making this argument right now to either suppress or kick out the interrogation. That's not this conversation. You need to put in a motion for that, and then we have a whole other hearing to hash this out. However, this conversation right now needs to connect back to the Miranda policy. How does anything that you are saying have anything to do with anything about that Miranda card? That card is not what you need to make the argument that this is unconstitutional and should be thrown out. You need case law. You need facts. You need details. You need emotion so that they can actually rule on that. But this is entertaining. I'll say that. I'm having a good time.
The Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted.
Okay, now I see. That's not a terrible argument because that last question is asking, does she knowingly waive her rights? In order for it to be understood, you have to knowingly, intelligently, and voluntarily waive your rights. So she understood her rights through the rest of the questionings, but did she voluntarily waive her right? You know, that is something that can be argued. I would say absolutely still yes, because you can argue the totality of the circumstances, which is given the context of everything involved, did she know her rights and knowingly engage with the police? We know she did. How do we know she knew her rights? Because she called the police 16 times in 1 year on Jorge Torres, the man she murdered. I'm going to assume in those 16 times, and she was arrested a few years prior to the incident, she is familiar with her Miranda rights and the Miranda warning. So you can argue that her past interactions with the police means that she has an understanding and an awareness of her rights, and that by continuing to speak to the police, that she is waiving those rights. She also engaged in the conversation. You can also talk about, well, one, it's like harmless error. And, you know, if it did not sufficiently impact the outcome the outcome of the trial or the case in general, then it's more or less fine. And it didn't. The video was so damaging that the statements she made in that room would not have changed whether or not she was arrested or charged for second-degree murder. No matter what, she was getting charged that day with second-degree murder. Her statements were just the nail in that coffin. And the other thing is she was giving details voluntarily. She was asked questions and would answer in a narrative that completely departed from the question itself. You can also look at the conduct of her in there. Did she have any contradictory statements or contradictory behaviors? We know she absolutely did. And if you can prove that she went to the police intentionally to manipulate and to plant a narrative, that is also meaning that you can prove she intentionally knew what she was doing and intentionally wanted to engage with the police, thus waiving her rights. How do you know she had contradictory statements and contradictory behaviors? Because now you're saying it's self-defense. And for 2 hours, she said it was unintentional. Those two things can't exist. So either you're lying in front of us right now, or she intentionally went into that police station to lie to their face, thus knowing that she was waiving her rights to remain silent.
I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other two
question.
statements.
Respectfully, that doesn't answer my question.
And
I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
Then you are not ready for this conversation. So we need to move on. You actually do have a better argument than I thought you did, because yes, you need to establish that she waived her rights. It has been established a million other ways. I don't think the state is going to have an issue arguing and keeping in those statements, especially once Cranick sees them, because, you can try to suppress certain statements. Cranick is not going to watch the full video until trial. I do not think he will let her get out of it. Knowing her past with the police, she is very comfortable talking to the police. She is very aware and understands law enforcement. So when she hears all of her Miranda rights, or all but one question, she says, "I understand," and continues to speak anyway. She knows she is waiving that right to remain silent. And in the first one, like when she was on the crime scene, Chelsea stopped after the first question and said, "You have the right to remain silent. Do you understand that?" Yes. She gave multiple confirmation. And the difference is, just because you confirm that you know what your rights are does not mean that you waive those rights. So that is what he's parsing out here, is that they didn't say, knowing these rights, do you still want to talk with us? Meaning you are acknowledging that you are waiving those rights. Even though it's pretty implied by all of her other actions, he still has something that he can argue, which is better than nothing. I'll say that. So I was very judgmental at first of like, there's nothing you can do with this. But with that question, it is, there's something at least. It's not going to win still. But Cranick is done. He said, respectfully, that's not my question. Answer the question. What case law do you have to support your view? Which you should have researched and brought with you. If you knew that you were honing in on this question and waiting on that Miranda card, and you said you pretty much wrote up the motion already, then you needed to at least look up some cases where that question hinged on the admissibility of the interrogation or not. Find a case that says, because this one question was omitted, then the whole thing had to be suppressed and thrown out. Which I'm sure there's something out there that is similar to that, but then you would get into the particulars of the case around it and the context of the case around it. And then the state gets to go find all of these cases, which I imagine there are a bunch of, where there was a harmless error in reading the Miranda rights that didn't overwhelmingly affect the outcome of the case. And with that case law, they would look at the context of those cases, saying they thought that it was okay to have this mistake because the totality of the circumstances made it clear that this defendant understood their rights and intentionally, knowingly, intelligently waived them by continuing to speak to police. He does not have any case law. Technically, both sides don't. And that's why the state isn't arguing this right now. So we need to move on. If you don't have the case, because Cranick cannot just rule on his feelings. He has to rule based off of the controlling law surrounding the issue. He can't rule off of the controlling law if you're not giving him any law to consider. You're giving emotions, feelings, and arguments, which is fine. But again, you're doing that to suppress the entire interrogation, when we are still asking the materiality of the Miranda rights policy to this constitutional issue. If the Miranda rights policy and or card are not directly connected to this constitutional issue, we need to move on. I'm not hearing your issues right now about suppressing the interrogation or that you think it was done incorrectly. I'm hearing, like, you can bring in some facts in order to support why you think this Miranda rights policy is so important. As in, we need this right now. You need to prove to me why I need to tell the state to go get that little business card for you.
that you could probably Google. So this back and forth looks like arguing, but it really is just Cranick recentering. And he can be more forceful with Mr. Owens. He was on the kid gloves with Miss Paulson because she just went around the world and said whatever she wanted, and he was careful because he knew if he pushed or tried to recenter or refocus too much, then she could have some appellate issues of she threw a tantrum and then caused all these issues, yada, yada, yada. But with Mr. Owens, you know better. You know what I'm talking about. You have your talking points that you talked with Sarah about, and she is demanding that you get this narrative out there. That's why I think he's continually to go on, as in extending past the question that was asked, is in order to get that narrative out. It's the same reason he brought up George's brother outside in that press conference, outside of the hearing. That was unprompted. It's because he's trying to paint a specific narrative on the record that he can then argue later. However, this is not the time and place for this specific argument.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper. That they're used to coerce somebody to talk. And I understand the detective, they had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right.
Now, I will give Mr. Owens his point, because I actually wanted to go on a little rant in the other direction, but I'm like, no, be objective. He has a good point. She did say, we have to talk about that, so I'm going to read you your Miranda rights. And that can be seen on its own as coercive. However, when you play it and actually hear it, she's not forceful about it, and it doesn't sound like it's coercive. The way I read it in the light most favorable to Chelsea is that Sarah came there to talk to them, and has definitely, I'm sure, in that walk down the hallway and as soon as she saw them, has mentioned the things that she wants to discuss, or that she wants to discuss X or Y. And in my mind, when she says that, it's like in order to talk about anything else, we have to talk about the autopsy. Still coercive or on the line, but I think it was feeding into Sarah's desire to already speak with them, because she definitely had a desire. She did nothing but talk to the police the day prior. Anyone who would listen. She said, my rights where? My rights, I don't know her. My rights to remain silent, I think she missed the bus. And she decided to exercise her First Amendment right instead and use her free speech and just tell everyone everything. And then tried to plug in the holes today that she realized she told while she was in a manic episode or just off the walls. And that's another thing you can tell between the days. It was literally one day she has the car interview, the next day she has the interrogation, and answers changed overnight. So we know she came into this interrogation with a plan, with a narrative she wanted to establish. So she was going to talk regardless, just like she will 100% be testifying. She will. Like, that's not even a question anymore. She will. Her type of personality cannot let it go. And I'm not saying any kind of mental health condition. I'm just saying her specific personality cannot let it go at all. She has to get on the stand and she has to tell her story. But this is similar, and I've used this case a bunch and might just get to it sometime. But the Depp v. Heard trial. Johnny Depp's team made a brilliant and foolish choice at the same time. During their rebuttal cases, they put Johnny Depp back on the stand. He should not have gone back on the stand. He had a great first testimony. He did not need to go back on the stand, but he did. And, you know, Heard's team got in some good jabs. He did not look as good as he did after his first testimony. However, it was a ploy to get Amber to get back on the stand. It is impossible that she would let him testify again and her not tell her story again. She didn't have to. And I'm sure her team told her not to and said, let us just go in on his story. They got in a few good jabs. They could have rode that and tried to, do something with it. But no, she said, I have to tell my story. Got back on the stand and got demolished for a third time by Camille. Goddess, icon, legend, inspiration, that girl. And the same thing's going to happen here. She's going to push to get herself on the stand because she believes, just like she believed in that interrogation, that she could just talk it away. She thinks that she could talk to the jury because the jury is not the judge and the jury are not lawyers. She 100% believes that she can convince the jury if only she can talk to them herself. So, betting my whole salary right now, she will be testifying unless they refuse to unchain her. And look at her talking with her dream team, surrounded by people, talking their ear off. She wanted to be part of a legal team this whole time. She wanted to be co-partners with her lawyers. She sent out that ad that is hyper specific and just the worst kind of ad possible. But nope, I'm wrong. I underestimated others' lack of self-awareness and willingness and attraction towards humiliation that they would actually answer this ad. And they did. And now she has law firms behind her. Well, no, not law firms, but law practices, multiple law practices behind her, including all of these lawyers, aides, whatnot. So, good for you. Good for you.
Not to speak to them without a lawyer being present. So she made those two statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the Sheriff's Office's policy, so these statements are clearly admissible.
Thank you. I like that. That's a good example. I like that he came up with that inverse example pretty quickly, but exactly, because that's exactly what he would be arguing if it were reversed. And there were some violations, but they did it correctly according to the sheriff's office. They would come in saying, look, they followed the sheriff's office protocol, even though they violated the Constitution. That means we have to let these in. And they would say, smooth and fast no. Smooth and fast no. And in this case, it's the exact same. Whether they messed up using the Miranda policy of the specific police department or not is not relevant to whether it broke the Constitution or not. That is an argument that you have with the judge, with your case law, going against the state. You are now in here saying that because these officers, who are technically witnesses, broke some policy that was given by a third party, i.e. the police department, that means the state is responsible for getting that broken policy card, clarification, evidence, what have you, to the defense. That's where the issue is coming. The issue isn't whether or not you can go back and forth on this. The issue is, what on earth does the Miranda policy at this police department have to do with any of this? If you want to make that argument, you make that argument. We are here right now, not there.
And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review They didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? Doesn't matter what the policy is, doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Exactly. Thank you, Mr. J. That was very good. It is saying it's not that you don't have an argument, but you submitted a motion for additional discovery from the state, saying you are asking the state to provide this for you, and then you're accusing the state of not providing it for you. So what does this have to do with anything? You have the video and the audio where she did forget an important question that you want to argue about. Okay, why do I need to give you more discovery for that? You are making it my responsibility and basically accusing me of not giving it to you originally, or not giving the discovery that I'm supposed to give to you. You are asking for something else that you can look into. That's part of your investigation. So glad we're done with that.
Okay. Thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is, I think state versus right is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Bon appetit!
And there it is. The state does not have to prove anything for you. And that's exactly what you are asking. You are asking the state to help you build your case.
Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing, and we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected, so no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll have to ask Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I give you my copy?
And Mr. J, have you seen that, sir?
State doesn't have a dog in the fight with the expert one.
Understood. Thank you.
Judge, what I had done was
Don't see a date on here, Counselor. When was this sent? The certificate of services contains no date.
It was filed this afternoon.
Okay.
This morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, I believe August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial. which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion.
I just don't get how he was convincing people to make these big travel arrangements, but okay. And if she diagnosed her with battered spouse syndrome after those interactions, I was going to say just a brief amount of time, but let's just say she's met with her multiple times, whatever, then she is putting her own license and reputation on the line with that one. Good luck. And this is why I have an issue with forensic psychologists and forensics experts in general, is that you can just buy an opinion. It doesn't matter, really. You can literally pay them to tell you whatever they want to say. Does she check enough symptoms of battered spouse to say that? Sure. But within the context of who she is, as what I believe is the primary aggressor, antagonist, had more control in the relationship of who can stay, who can go, then she absolutely does not have it. So you're going to get up on that stand, you're going to try to explain it, you're going to see that video, and you're going to get annihilated on cross-examination, and that's just going to be how it's going to be. But she got the defense. She gets to run this unintentional self-defense. Well, it's not unintentional. She is now saying it's self-defense. I need you to prove to me how you were in danger. When you told the police nonstop, it was such a great day. Everything was fine and dandy. No one laid a hand on anyone. It was truly a great day. It was the alcohol. We were playing games. We were both laughing before I zipped it up. And he was laughing too, but then I fell asleep. So now you gotta turn that into a self-defense of, it wasn't a great night. He was actually yelling at me a lot, and he came after me, and he attacked me. So I waited until he got in a suitcase? Or, yeah, it's still unknown how he got in the suitcase, truly. I honestly don't think it is impossible for her to get 103 pounds in a suitcase. I don't. Maybe I just have more faith in women than the average person. I think women can pick up 100 pounds, especially if they're on an adrenaline rush. You've seen women pick up cars to save their kids. So picking up a 103-pound male, I think is possible. And when you're full of rage like she was, and that is such a specific humiliation to confine someone in that way, she was determined with that method. And that is what makes it truly horrifying. And I'm sure by that metric, you could probably diagnose George with battered spouse as well. And especially when you hear him begging for his life in that video, he's not aggressive. He's, again, defeated, like we've seen in all of these body cam footage where she's called the police on him without him knowing and omitting the fact that she attacked him as well. We went over in the last video, she's calling 3 or 4 police officers to the stand, and almost every one of those incidences are when George got arrested, and so she's going to use that to support that she was a battered spouse. However, in every single instance, he also had injuries. He just refused to say anything about it and never called the police. He couldn't call the police. He didn't have a phone. And he did have a phone, but I think it was just a Wi-Fi phone. And yeah, you can still call the police on that, but you have to really want to and think about calling the police. And if you're a male in an abusive relationship where you are also physical, odds are and if you're on the smaller side, odds are you are going to be hesitant to call the police. And he was. And even when they were in front of him, he denied it most of the time. Then he finally admitted it sometimes. But even when he admitted it, he would not go into specific details. And I mean admitted that he had been abused as well. And so it's really hard for me to see this as a battered spouse syndrome, given the context of all of it. And if she's going that route, I'm bringing in all the body cam footage, all of it, to show exactly how she acts so that you can hear the affidavit and you can hear what she's going to say on the stand, and then you get to see her, who she actually was at that time. And Sarah even admits in her interrogation, I don't remember where it is, but it's in there, that George doesn't have access to the cell phone. She admits that they both shared the phone, but then she admits, oh, only I have the password and only I have the facial recognition. And so Chelsea's like, well, then how does he get on your phone? Oh, he just comes up and he asks, can I get on the phone? Or he'll put the phone up to my face to unlock it. So she literally had complete control over it. She is the only one who could freely call the police in this mutually harmful, violent relationship. And now she's trying to paint a heavy, one-sided picture. And she has pictures and evidence on her phone because she said, at some point, I started to document. And that's what she did. And normally, if a victim starts documenting, it can be helpful in order when you are ready and when you feel like you're safe enough and in the position to come forward, that you have things to prove and you have things to show others. However, if you flip that and an abuser starts to document things, that is just a further manipulation tactic of, I know we both go at it and we both are left with marks, and I got in trouble for leaving strangulation marks on your neck one time. So I need to start documenting every little instance that you do anything to me. So if things go down, they are getting all of it and you have nothing to show them. The only pictures of George's injuries we have are from police officers and mugshots. What about all those injuries that we never got to see and that he never reported and that she didn't call the police on? It just makes the fact that she said, I thought he was the boy crying wolf because he's done that in the past, just light up every red flag imaginable. That means you've put him in dire restraints before where he has sounded like that, sounded defeated, and you ignored that. So Dr. Harper is going to have to do a lot of work to explain all of that away.
But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last...
When was that, you're asking Nunc Pro Tunc to win on that? Also to the August 30th date of your notice of appearance?
If possible, yes. That's when I officially got on the case.
Okay. Now, as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I had mentioned him. He had served as an expert in the Marcia Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Berkland. And it doesn't address Dr. Brannon, and notably, JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. That's what the state's request is going to be.
If you couldn't hear that, because that was really quiet, I actually had to get to my speakers. But Mr. J said that the state doesn't have an objection to the new psychologist and the crime scene, all the new forensics experts. However, he wants them to write and submit a report of what they plan to testify to. He said he doesn't need a report from Dr. Harper because a deposition is set, so they are going to ask all the questions they need there. However, they want all of these new people, because it is, quote, the eve of trial, and we have no idea what's going to happen, for them to write up reports and send that over. I think that's completely fair, and I think that's probably what they'll do.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central?
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick. Judge.
Sure.
Give me a minute.
Yeah, you're good. While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
With
It had to be filed prior to my motions for appointment of these experts.
Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berglund and amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided.
Okay, I use that as my little break because this thing is so long. I can't believe I still have so much to react to on this. But whatever, it is what it is. Yay, she got all of her experts appointed that she wanted. That wasn't really a fight. The state had no issue with any of it. They just wanted her to submit it properly, and they did, so it's approved. Yay, win for you.
Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone.
She's doing it again. Oh my gosh, how many times are we going to hear about this damn phone? I am so over it. They gave you the digital mirror imaging of the phone digitally. You didn't know how to open the files, so you said it wasn't there. The state explained that sometimes they're a little difficult to open, and I imagine they were going to explain it to you afterwards. Then you got it in hard copy. So you have it two ways. And you acknowledge that you were looking at the discovery on the laptop after this initial debacle. Then Mr. Owens shows up and he asks for the digital mirror imaging of the phone. They give it to him again on a hard drive, on a USB drive. I think it was a 32 gig USB drive or something like that. And none of that is good enough. She still wants the phone herself. They told her she, Miss Sarah Paulson, will never lay hands on that phone again. She wants that more than anything. And I can't believe I can only imagine how long she wore him down in order to say, get the phone, get the phone, get the phone, get the phone, again. And they're going to hire their own expert, and she's still not going to see it. Like, they might let her be in the same room as the professional expert is imaging the phone, but then the phone goes away and she gets the report, and it'll look exactly like the mirror imaging the prosecution did. Why? Because it's their evidence. They would have done it properly the first time. They wouldn't have not imaged it properly and then given it to both sides and say, we're both going to work with not everything on the phone. But because you don't trust anyone, because you think everyone fails at their job but you have to get that phone and image it yourself. You have to waste more taxpayer dollars with your broke ass to get another expert paid, waste all of this time. You only have a few weeks, and you are prioritizing your time in the wrong areas. You have absolutely everything that was on that phone, but you don't believe it. And if you can't understand that because things are so jumbled up, it's probably because they handed it to you and you messed everything up. Everything's disorganized because you were trying to organize it in a way that made sense. And I'm sure there was a whole bunch of issues, but you did that. You begged for it. You begged for it when you had attorneys. And she asked for a mirror downloading of her phone. Now, I can't remember, but I do remember hearing it in a few of her letters in the past, that she is wondering, why can't I have a mirror imaging, mirror download of my phone? They've given it 3 times already. And so now they're going to hire an expert of their own to image that phone for a 4th time. Well, actually, it's not for a 4th time. For a 2nd time, in order to give her an imaging of the phone for the 4th time. And then what? What then? Do you really think like the evidence that's going to crack this whole case is on that phone, and that the state decided not to give that to you? Well, I know that's what you think, but I guess we'll see. I just can't believe it. So many thousands of dollars, so much time wasted on giving her things she already has. That's why it's so annoying when she asks for so many things, because she makes them all seem like they're the same weight priority-wise. That Miranda card is just as important as her phone, is just as important as her spouse defense, is just as important as everything else. And when you heighten that level to every single request you've given, it wastes everyone's time, makes everyone upset, backlogs everything for everyone else, because now we got to figure out, what do we do with you? Because you will not shut up about this phone. And I say it all the time, but this is more proof of how she asks questions and how she treats people in a circular logic argument, logical fallacy that never ends. She wears them down, wears them down, wears them down, to the point where they have Mr. Owens up here again asking about the phone. She asked about the phone in the past 2 hearings, and they have given her the exact same explanation every time.
No way. I want to see the receipts.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom, and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the AAC and him, whether or not he wishes to work for you and at what rate, and so on and so forth. And then that examination would be done by him, with us being present if we wanted to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mere download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline, but there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. What, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader, and then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We are going to make sure that that is taken care of.
Just as clarification, from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. You have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy, mirror download of my phone. If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone, of the phone.
Thank you
You're
very
welcome.
much.
I want to see receipts.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be photographed and physically examined. But in order for it to be turned on, it would have to be done at a different location where there's something called a Faraday box or a room where electronic signals cannot come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So, like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by law enforcement.
Thank you, I'm grateful.
Welcome.
Okay. So do you see what I mean? She is relentless. No matter how many times they told her, you cannot physically touch the phone, you cannot scroll through to try to find the context you want. That is not how this works. It has to be done in a special box that will not change the evidence on the phone if it's turned on. All the radio waves, Bluetooth waves, magnet field, the Magneto comes out of the earth and just points at it and it says, Kalima! And then the phone just explodes. We can't risk that. So we have a special box for that. She don't want to hear it. She can't take it. So she asks again and again and again and again. I think on the 5th hearing, she asked 3-4 times in a row after they gave her the exact same answer. And then we waited a few hearings. Well, no, the hearing in between, she complained that she couldn't open any of the files in general. And then she decided to complain about it again on the August 14th hearing. It's just mind-blowing to me how many times people have tried to get her these things, but it's not in the way and form she wants, so you're not doing it. It doesn't matter how you got her the digital discovery, how you got her the discovery in general. It wasn't the hard copy, so you didn't get it to her. And then you got her the hard copies, but you didn't give it to her because there was no staples. It was just freeform paper. It was all over the place. She has the paper. She has the hard copy. She has another jump drive that Mr. Owens got after his first hearing with another copy of a mirror imaging of your phone. You keep asking for it as though the answer will change. And you're going to hire another expert who's probably going to use the same technology that the prosecutor did. And they're going to do the exact same thing and send you the exact same type of report, where one will be the long PDF with the table of contents and all that stuff, and one will be the humongous one where you need special servers in order to read it, and it's difficult. That's probably why it wouldn't open on your little jailhouse laptop, because it is such a huge file that it is even difficult for the state to sometimes read. It doesn't mean the defense hasn't had it for 4 years now. You yourself personally can't open it. So you are saying you have never been given it. And you are saying all of your lawyers never went over anything with you. I don't believe that for a second. What's the point? Do you think this is Scott Pilgrim and it's Sarah Paulson's evil ex-lawyers and they all get together and they're like, we're not going to tell her stuff. We're going to keep secrets. Look, I kept this file. You kept that file. You kept that, this and that. But wow. No matter what, still complaining about the phone. And even today, I told you she can't let anything go. She has Mr. Owens file a whole motion to return the property to get the cell phone. Because what? She wants to just turn it on and go through and look through her contacts. Because in her mind, it should work that way. So she's going to keep saying it until it does work that way. And she's still not getting. Even if this motion is passed, you will hire an expert. The expert will have the phone in the special box, conduct their own analysis. You still don't get what you want. And I can't wait for you to complain about it. And to say, how do I know he did it right? Because I didn't actually touch the phone and see it myself. People's contacts and numbers that are in the phone, I don't see a world where that is not included in the mirror image given. But that's not what she's really looking for. I don't think it is at all, which is why she's saying she can't find anything. And she's like, well, I just need to look through so I can find the contacts I need and get this and get that. Also, do you not know the people in your life? No? I mean, Billy Lane is there to investigate these things for you. You can give him names and general locations and he will go and seek them out, which tells me that there is something else on that phone you want to slip in when you have it in your grubby little fingers for 2 seconds. Because if you actually are doing all of this just for a contact list, you are literally dumber than I ever could have imagined. But if you're doing this for another nefarious reason to try to get the phone and look for whatever, probably try to find that golden picture that shows the abuse that you're looking for or what have you. Still dumb, but at least it would be more productive than looking for a contact list. But no, you don't trust anyone, so you are going to waste this time hiring a new expert and finally getting the exact same mirror image that the prosecution did. I know I have driven this point into the dirt, but I can't get over how many times she has asked for this cell phone. And if she had different requests, it makes sense. I'm on board. I get it. New things pop up. You didn't think that you needed this, and now you do, and now you have no idea how to get it. Please help. Okay, cool. Let's see what we can do. But the same thing, and no progress is ever made with it. I already know. I'm driving it into the ground because I know she's going to complain about it again, and I'm already over it. But okay, I'm so over it that we're moving on from this. I can't stay on this anymore.
So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that's been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property.
Bon appetit!
Based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best. We got about 18 days.
Sure do. Yes, you do, which is why you need to prioritize your time. He's saying that as though oh, woe is me, feel sad for me, I have to get all of this done in such a short amount of time. I don't care. I don't care one bit. It'd be one thing if you've never had a mirror image, but you want this for the 4th, 5th time. So do whatever you want to prioritize in those 18 days, and when that trial date starts and you have nothing prepared, you turn to your client, you give her a thumbs up, and you say, we are going to crush it. And then watch her hauled off to prison.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert, and there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome.
Here we are, finally. This is finally covering the documents that we went over in our last video. I can't believe it has taken us over 2.5 hours just to get here. Is that my fault? Sure, but I'm going to pull a Sarah and blame it on everyone else. It is Sarah's fault that I messed up and kept talking.
The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. Discretion of the court.
I don't know if y'all heard that, but basically Mr. J said, one lawyer, one motion. You can't just pass it off, tag in, tag out. One of y'all has to start in this motion, which I think Mr. Owens was about to explain.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion that whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. Okay. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance, and Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting.
Vetting or begging? Because I just don't believe that there were all these people jumping at the chance to represent Miss Sarah. I don't see it myself personally. Maybe there were, but it sounds like we were begging anyone who was willing to travel there. And she said she already put in the hours, already put in the work, already canceled her vacation plans one time for this trial, might as well go for round 2, sign me up for the circus show. Welcome to the stage, Dr. Julie Harper.
And we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting, and then on Friday I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday.
we get that. You were doing the best you could under the circumstances, but that still doesn't mean the state should let that slide. If it's not done properly, then they need to call that out, because there's no point in trying to help you. I think Mr. Owens is taking this a little personal sometimes, as in he believes just because he's trying hard that people should just accommodate. He's really, there trying to do the best he can, so he should get the continuance. He's doing the best he can, so he should be able to run this defense and, submit all of these motions that have something, a little something here and a little something there missing, to where he has to amend the motions and send them back again. I think he's taking those as personal attacks, when it's really, no. Honestly, if he started at the beginning of this, I think he'd be in a very great spot, and he probably would have built a great rapport and everything would be running smoothly, yada, 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 yada. But jumping on a month before the shuttle takes off and expecting people to give you all of this leeway is just a little naive, just a little bit, because it's not realistic. I mean, maybe it is. Maybe he genuinely thought it would work. I didn't, especially because of the publicity of this case. If no one knew about this case, maybe the judge would be more inclined to be like, okay, fine, I guess it's not that big a deal. But when it has this much global attention, has taken up this many resources, is constantly being talked about and clogging everyone else's list up, we need to get her through the system in the interest of justice. So, Judge Kranig has decided this case is going forward. Appeal it all you want later, but we just need to get you out of here. And so you're having to deal with that pressure, which is a lot. And I will give him his props that he is trying and he is holding his own, given the stress and the circumstances of what he just walked into and the weight of that case that you just took on. And then just the emotional trauma he must receive from Miss Paulson just as a client. Because they said they got in that shouting match. Remember, it was August 26th, and the IMS record, behavioral record, said that the officer heard loud shouting in the middle of the hallway, and they had to find where the location was, and they found it was in the briefing room with Miss Paulson and Mr. Owens. That resulted in a shouting match. Who do we think was yelling? Well, I can't even imagine what a Mr. Owens yell sounds like. It doesn't sound like it would have that much of a bark. But Miss Paulson's yell, could break glass. It is powerful. It just means, of course, she would start shouting at him if she was met with pushback. I don't even know where this tangent began. And you know what? I'm going to leave this in because I need to teach myself a lesson on how to remember a train of logic. Now, where were we? Oh, Mr. Owens was saying, poor me, woe is me, I'm trying my best. Yeah, you are. Good luck.
And of course, I had just gotten discovery. Judge Kranig, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down.
That's what I said earlier. I mean, he said he was going to have to do that, but now we have confirmation. Yeah, he has pushed everyone else aside for Miss Sarah. She is that important and that special, and she is going to shout at him if she loses.
To try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on her phone. So we're diligently trying, number one, to review all the discovery, which still has not been done, at the same time trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome.
Judge Kranig could not be more unimpressed by this. He is like, can we please move this along?
In addition, The state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial.
I thought it was 18 days. That's just me being petty.
She told me that there was quite a bit of it, that she would try to get it to me after the hearing, or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through.
Okay, this tone is throwing me off a little bit because it sounds accusatory at first, like they said they're amending their list of discovery. They found this new thing. They have all of her tablet records, communications for over the years, which, yeah, they do. They have access to all of that, and they can also pull every phone call that she's ever had. That's open to anyone. So yeah, it's going to add more things. Everything you do in jail is recorded. There is no privacy. Sorry. So at first I was like, oh, are you saying they didn't give you everything in a timely manner? Even though you said you gave the CD today, they told you they would try to have it by the hearing. It doesn't look like that was possible. I mean, also, it's a CD. Who's using that anymore? And then they figured out they could give it to you by email, probably through a Dropbox or a zip file or something like that. So they problem solved and got it to you even more efficiently, and we're still in this tone. So I think it might be just a general frustration, which I can understand, but it's coming off as accusatory, and I don't know what he wants anyone to do about it. It's like, you're telling me you have a lot of work to do. Uh-huh. Yeah. Yeah, you knew that. You knew that. Did you think that you were walking into a case that had everything just laid out? So I think he is waiting for some sympathy and compassion that is not coming his way. I mean, it is coming his way. A lot of these motions are going to go his way, just not these dumb ones that don't matter. But like this battered spouse one will probably go his way, but he's going to pout his way through this argument, and then Kranik's going to throw the bone then. But we're not giving you the compassion now.
The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday, I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, Jorge Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone.
Yeah, he was prosecuted because she called the police 16 times in the past year. Again, they've been together. They were together for like 3.5 years. And she called the cops on him that many times and got him arrested that many times, and then bailed out the next day, and then sent so many policemen away. Because we did the math. Of those 16, 8 of those were verbal where nothing happened and she was able to have the police come in, scare him, and have them leave. At the minimum. There's more than just that 8, because I think he got arrested like 5-ish times. And she decided when she wanted to prosecute, when she didn't. It was never based off of the injuries or the story or anything. It was just how she was feeling that day. And that's just what you hear on the surface. But then when you look at the affidavits and you find out George was injured on almost every single one of those occasions as well.
They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Okay, now we're doing a bit much. You know it went both ways. I get it, you're doing your job and that's what you're supposed to do, but from my position of opinion where I don't have to be objective and give everyone their fairness 100% of the time, I don't like it. Calm down. You know she was just as violent. Literally just as, if not more. And by all the presentations we've seen, everything on record, even in the affidavits, they made notes that she was upset, that she was the one who was loud and this and that. And every single arrest was made without incident on his side. As in, he didn't fight back once. And of everything we've seen, he didn't even talk to the police. He was way smarter than Sarah. He knew when to shut up around the police. And even when he is alone, he doesn't blame it on her. Like he did when they were asking him the background story, but there was that 23-minute cop car ride where it was just him and the cop was actually empathetic with him because he's the one who did not care about Sarah's story whatsoever. He did not believe it, but she was saying all the right words, so he had to arrest George anyway. And as soon as he got in his cop car and was driving George away, he revealed his true feelings. And he said, hey, if she's going to keep getting you in trouble, you have to stop going near her.
No way. I want to see the receipts.
Look, man, she's going to keep getting you in trouble. You got to stop coming around her. Right? Or no? You don't agree? That's up to you.
And I give props to the officer for that. I have respect for him for that, trying to give that warning. I really wish George would have listened, but as you can tell, that silence is what he gives everyone. Everyone in his life has said, stop going around her, get away from her. And they've all probably been met with that silence. And they have responded the same way of, suit yourself, it's your decision. But yeah, that just means after all of the theatrics, she said that she was fighting for her life, that this and that. She was punched in the ear. She ran barefoot to her. She had to flee away. She was sleeping. He came in punching, all of this stuff. He didn't believe a word of it. Because if he did, he wouldn't get in there saying, if she's going to keep getting you in trouble, you have to stay away from her. The one consistent thread from absolutely everyone on this planet, even Sarah herself, is that you need to stay away from Sarah until she wants you around.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotapes, please look at the photographs. I need my phone to show you. He comes at me.
She sure did tell them to go in her phone and look at all of those pictures, all of those injuries, but just like everything else in this situation, she didn't instruct them to go look at the videos of her killing her boyfriend. She only instructed them to go looking for the injuries, everything that he has done to her. Do we see the picture here? I mean, it's honestly a foil for this whole thing. She instructed them to go look for evidence against George, completely ignoring the evidence on her phone that implicated herself, just like the evidence that implicated her in 2018 and any other time she's gotten caught. But in her drunken stupor, the same exact thing is happening where she doesn't think she did anything wrong. So she's surprised by it every time. And then when they confront her with it, it's this, what are you talking about? I wouldn't do that. It was an accident. I was fighting for my life. It wasn't me. Meanwhile, she has done nothing but intentional acts of psychological and physical torment on this person. If I'm the state, personally, I'm loving everything I'm hearing because you're getting a taste of how he's going to argue at trial. And it is going to be 100% point the finger at him. And the more you do that, the more you fall into Sarah's trap of point the finger, 3-point back. She doesn't understand the irony of her harping on that in her letters when all she does is point the finger somewhere else. And when she does that, she won't even notice the 3 fingers she pointed right back at her. And in this case, it was 2 videos and a picture were her 3 fingers pointing back at her when she told the police to go in her phone looking for him. And honestly, they did. And they found him and found exactly who you are and what you did. And just like with every other incident, you want them to ignore what you did and only punish him again and again. The suitcase wasn't enough. She's going to punish his memory, completely reframe, repaint, reconstruct who he was, because a lot of us just assumed he was this violent, abusive person. When you hear that you gotten arrested all of these times and that there were injuries on the scene, you just think, oh, you're just this horribly violent person. And yeah, he was violent. But then when you actually look into it and you see that a lot of these injuries were pretty minor, there were some severe ones. There's no denying that. However, not as many as she has painted them out to be. And in all of these, she has completely omitted the fact that she has injured him so many times. And a lot of the times, it seems to trace back to her aggression amping things up. But we don't hear that from the surface of it. So you have to look into it. And then when you see these things and you're like, oh, this is not what it seems. This is not what she is telling me it is. And just like she believed that she had a right to everything in his life, she believes she has a right to everything in his death, including his memory. However, the evidence will reveal who is really the monster in this, who was really the aggressor in all of this, and who was the actual victim. She is sending herself to jail for the rest of her life, and it might take maybe a decade for her to finally realize that. Behind bars.
It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do.
Then why did you strike it in your last motion? I mean, you didn't really make an argument against it, but at the very end, you were like, we ask that you deny all of these motions and including the state's expert examining Miss Sarah. And you should have done that. But it's funny. I don't know. I get it. It's funny.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
Since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres.
And what I think he's getting wrong or not quite seeing is that they're not saying you're prejudicing them. They're saying your statement to use this, like your announcement of this defense, was incorrect. It was improper. It wasn't properly supported. They can't just let that slide. You submitted a motion. They have to respond to it. They're not going to respond to it and say, I know this lacks basically everything you need to properly submit this motion, but just let it slide. No, they have to at least say, strike it all down. Why wouldn't they? Why would they not make the attempt to strike it? They know Kranek is going to pass it anyway. Everyone knows that because she has to be able to run some kind of defense. It's not going to work. Like, it's not going to work at all. But I do think they should get their motion in limine about she can't bring these things up before setting a proper foundation. The issue isn't that you're prejudicing them. They are ready to go. They have their people. They have it lined up. But in their response, they needed to ask for their expert to be able to examine her and ask to strike everything. Do it right, and they wouldn't have done that. But, I mean, it's their job, just like it's your job to make these horrible characterizations of Mr. Torres. It is their job to try to stop you at every turn, especially when you're a lawyer.
I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible.
We'll get to insofar as possible, but you just glossed over that, including a statement of particulars, because you didn't do that. You asked for one from the prosecution, but you didn't do it yourself. And then when you finally submitted your amended one, you did give it, and it was just this tiny little paragraph. But you just read that when you initially announced this defense, you are supposed to include a statement of particulars. Why on earth wouldn't they try to strike it if that is not included? Just saying.
Insofar as possible. I did the best I could, Judge.
You doing the best you could does not meet the legal standard of insofar as possible. It was possible. Improbable, not feasible, not easy, sure. But it was possible. Why? Because you had discovery. You had the prosecution's witness list. You had all of the witnesses in the discovery from prior lawyers. You could have combed through, found some names, put them on there just to beef up the motion and then amend that list later and say, oh, we don't need this person, but we do need this person. But when you have more than just one Dr. Julie Harper listed, then you have more to work with. You only put her. In your amended motion, you added the 3 cops and Brian Boone. We'll get there. You added those 4 people. That made it look better because you're not just relying on one expert witness. So again, stop taking it personal if you didn't do it properly.
In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense.
Ding, ding, ding. There we go. Yes, just because there's domestic violence between a couple does not mean that battered spouse syndrome applies to it. First of all, it's also a defense that people are shying away from. Also, it's not actually a defense. It's self-defense is the defense by way of battered woman syndrome or battered spouse syndrome. And so they look for doctors who, under the DSM-5, battered women syndrome was listed as a subcategory of PTSD. It was. But that is not the most updated diagnostic statistical manual. That's a mouthful. But the DSM-5-TR is the most up-to-date one, which changes that language and generally doesn't recognize that. But I imagine a Dr. Harper will be using the DSM-5 to support her diagnosis, which would be helpful for the state because then they get to have someone using a more current and more recognized standard of diagnosing people and seeing that just because there's an abusive relationship does not mean you were in this sustained traumatic headspace at the time that you committed the crime. That can happen, but it is in very rare cases. That's why it is saying when you are in imminent fear, I am in constant danger, I cannot escape my abuser, there is no way out.
Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her?
No, but do you know who was isolating someone? Sarah was isolating George from his family. And then in the crime scene body cam footage, she tried to play it off as like, even though I encourage him to go see his family, because she realized she slipped up saying he chooses me over them. Even though I tell him that he should just go visit them anyway. No, that is an isolating tactic of, well, it's not an isolating tactic. It's just a red flag of people who use that language are often ones who encourage the opposite, because then they get to reinforce when something goes bad that only I am here for you, which is why she would do anything to rile them up. Every time he's on the phone with someone, she's yelling, tell him what you did to me, tell him you beat me, tell him you this. She got him beat up and sent to the hospital by one of his brothers. I think the same brother that she is trying to use now to say that George was just as bad as him, when it looks like that brother was violent all the time if he could send his own brother to the hospital over a fight. However, the origin of the fight was Sarah barging in, telling everyone who was there that George beats her. Confidently, she states that to anyone. She stated it to Melissa. She stated it to anyone with a pulse. I do not know any victim who is that comfortable telling everyone that moves that they are being abused by their violent abuser, and in front of him, having the nerve to say that in front of him. It does not make sense. It doesn't track with anything at all. And on to Mr. J's second point, did he tell her, if you leave me, I'm going to kill you, or whatever the phrasing was? No, but who actually thought that Sarah was going to kill George's family? And Sarah knew that. Sarah knew she had a reputation of people thinking that she is capable and will kill George. And then she did.
No way. I want to see the receipts.
But yeah, they're gonna know what we're here, what we're investigating, and that they're gonna think I killed him.
Why would they think that?
They always have said that. They've always have said that. They don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I have encouraged him numerous times to go over there and see his family.
I wonder if Mr. J picked those two examples on purpose, because that's exactly what she did. She didn't technically threaten him. She may have. We don't know what their actual conversations were like. But with her actions, she threatened his life multiple times. And she heavily isolated him from any kind of support system other than her.
We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her.
That's a new detail. From everything we heard, he never touched her. But I mean, this makes sense, right? But he had to hold her down to stop her from hitting him. Now, I believe that, because I'm like, she wouldn't just stop on her own, I don't think. But I do believe he did not hit her back, but I do believe he would try, self-defense, to stop her from hitting him.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence.
And there it is. Pretend I said what he said earlier.
The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day.
She sure did. She was pleading with Chelsea and Scott to believe that nothing violent occurred. Nothing at all. So when is she lying and when is she not? And when do the lies stop? Right?
I want to see the receipts.
I miss him a lot. I mean, is there any chance it got to be too much for you and you couldn't handle taking care of him and
I never stopped.
trying to...
I never stopped. That's what I'm here for. I never stopped. I'm here now and I'm still trying to help him.
Yeah, we just don't, I mean, it's unexplainable how he got these injuries, and
I have no idea.
you were the only one with him.
100% right hand to God. I have no idea how he got them. Nobody touched anybody. Nobody touched anybody.
Okay.
100% right hand to God. Nobody touched anybody. So do we need to call God as a witness? Because, wow. Yeah, she was very, very emphatic and enthusiastic that no violence happened, that she helped him, that she did everything good for him. And now she's saying she was in fear for her life. It was self-defense. Even though I told you multiple times, he did nothing to me that night. It would have made infinitely more sense, I mean, if this were true, for you to say that on the spot. Say, I was terrified to let him out. I ran away. I called Brian. I thought he was going to come over. I got too drunk. I didn't notice. And then when I came back, because I always flee and I just assume he would get out, and he didn't get out, and I was terrified. I had been beaten all these times, and so I just got him in the suitcase somehow, pushed him down the stairs after a fight, and then I ran away. Nope. She went upstairs and fell asleep. She has spent years planting her narrative, never-endingly telling and saying her story again and again and again. And now the evidence will get to speak for itself.
So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol-related. But it doesn't go on to say this violence has caused her to suffer from the syndrome, and here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case, allows the state to point out the things that are promised in a defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them.
And that's reasonable. That's a reasonable request. They didn't give any specifics. They were just saying it's an abusive relationship. There's been arrest in the past, or maybe, I don't even know if they put arrest in the past. They didn't put any proof in there. We have these medical records. We have these arrest reports. We have this, we have that. He did this, he did that. They didn't detail that out, and I get it. You don't have a lot of time. However, if it's not submitted properly, the state can't and shouldn't just let that slide.
Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
He already cut in. He said, I know you're about to go on a diatribe that I don't care about. What is your defense to what the prosecution just brought up?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but...
I want to talk about Wagner because I read up on it a few days ago. I don't remember all the details, so I'm paraphrasing it, but it's a pretty cool case, and the way they're applying it here makes a lot of sense. I mean, it's not a cool case in terms of what happened, but in the precedent it's set later on. So basically, it was this husband and wife. They both claimed each other was the aggressor. There was a fight one night, And the husband admits that he had her on the ground, pinned to the ground, and took her phone and smashed it, like threw it against the wall and smashed it that way. He says that it was self-defense, something, getting that away or whatever. I don't know. Then they separate. They leave. She leaves the house. She gets away somehow. I don't know if it was getaway or they just separated. And she goes over to the neighbors, and the neighbors are not there. She's upset the neighbors aren't there. She calls the husband and is walking back and is saying, I want my keys, like the keys to the car. Like, give me my keys, give me my keys. Then she pulls out a gun and points it at him. And he says, come get them. Or actually, reverse that. He says, come get the keys. And then she pulls out a gun from him about like 30 feet away. So they're a good enough distance, but still scary enough. And so he ends up tossing the keys at her, and the keys land like 3 to 4 feet in front of her. So then he leaves and he goes behind his door, closes the door, and starts walking down the hall. She says as she bent down to go pick up the keys, the gun discharged on its own. And it shot through the door and hit the husband in the back. And so then the husband crawled away, got behind the door, I think one of the son's room, and then told the son to lock the door and call the police. Then she went inside the house to get something of hers and then just drove away. So not good on that end too. So she was charged with attempted first-degree murder and was found guilty. However, she appealed it, saying battered spouse, or she tried to run that defense, saying that it was abusive relationship. She felt like she had no way out. So that's why she armed herself and she kept a gun on her. That's why this happened. Because she was in an abusive relationship, she had to buy a gun. And the appeals court upheld the lower court's decision and denied the appeal because they said, that's all fine and good. However, the issue wasn't whether she can own a gun or not. The issue was she knowingly pointed a deadly weapon at someone and then the firearm discharged. It doesn't really matter whether you pull the trigger or not. You had premeditated intent by pulling out the gun, pointing it at him, and then, demanding your things, threatening, whatever. He walks away. You bend down to pick up the keys, and I guess your hand is just steady, and then it just fires off. So the defense did not work because she kept claiming it was an accident. You can't be a battered spouse and then attempt to kill someone on accident. So the precedent that set moving forward is that you cannot claim battered spouse if you are claiming that the killing was on accident, which applies here because she said this was an accident. She's been saying that for years. She's been saying it was an accident up until maybe 2 months ago. So that has been her story. So it's a really great case for this specific argument. And that's why Judge Kranick is, what is your response to Wagner?
He's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony.
Yeah, but those two things contradict. He's hearing from the state that in the past she has claimed accident, which she has, and now all of a sudden she's trying to run the battered spouse defense. And you can't do both. It can't be an accident and you did it in self-defense. Kranick has only heard from the state saying that you have repeated in the past multiple times it's an accident. So the two-pronged issues are, one, this notice is not done correctly. So do we just ignore the fact that you did everything wrong and you literally submitted the most bare bones thing and then wanted to call out the state saying that their statement of particulars was too bare bones? So that's the first issue. Do we just let it slide because you attempted something? I think he is going to let it slide. Two, is it applicable? If this is hinged on the fact that it's an accident, it is not applicable. So now he's about to say that it's self-defense, but in all the times prior, he has not made that clear. As in, they have never officially stated this was intentional.
From Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
So you know the truth. So we're all on the same page. I think this is one of her first lawyers to actually admit that this could not go together. So now he has to completely pivot. 38 days before the trial, he comes in and completely overturns the defense that they've been trying to run for 4 years. Not that they've been trying to run, but the defense she has been trying to assert.
Right. So how is battered, even
it's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third...
Kranek is heated. I'm living for it, but he has reached his limit. He is done. He is like, this past bullshit that we went through the past hour, whatever, we can talk through that, but this is the serious thing. And you could do all this other stuff. We can go tit for tat. It's not really consequential overall. But you are trying to assert this a defense. This is what your defense hinges on. And it's not submitted properly, and it doesn't apply. So you need to make this fit now.
Legally sufficient. The court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
No, this doesn't make sense. The evidence is your evidence. Your evidence has to show that it was a self-defense measure. There's no evidence that suggests this was self-defense. All the evidence, including every one of her statements, is that it was a great day. No one touched anyone. That there was nothing happened. She even said, I don't have any marks on me. She said, I don't have marks on me because we have not been at it. He was the only one with marks all over him. And getting a statement of particulars from the prosecution does not make your defense. You were saying if we know what the state's position is, then that means the evidence will just appear that shows it was self-defense. What they're looking for is the state's theory of what happened so that they can look at that specific action and say that that was self-defense. So, was it zipping up the suitcase? If in the statement of particulars they said when she zipped them in the suitcase, he'll then argue it was self-defense. Or if the state said it's when she pushed it down a flight of stairs, then that was self-defense. No, the self-defense needs to be evident and it needs to be on your part. It is not the prosecution's job to point you in the right direction of where your defense should go. Wow, you are stretching this. You are stretching this so far. But on this record, in this open court, you can't step back. You are saying it was self-defense, and you said that we are not claiming it's an accident.
Was that the overt act that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at bar?
I assume they're going to say...
Stop saying what they're going to say. We're asking you, what are your points? It is not your job just to, in this instance, it is not for the state to prove anything to you. It is for you to prove your theory of the case. And you keep pointing at them saying, well, when they do what they're supposed to do, then I can finally leech off of their work and figure out what the F I'm supposed to do.
She overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Okay, but what does that have to do with your argument right here, right now? You need to claim self-defense. What was she defending, and how did she defend? Your client's the only one who can answer. The state can only proffer a theory, but you need to be like, with my client, she was defending herself. The state may have their theory of the case, but that doesn't matter. The truth is she was in fear for her life, and we intend to prove it because of their history of domestic violence. A lot of the times, things got violent quickly, especially when alcohol was involved. So they don't know what happened before, they don't know what happened after. We plan to prove that it was self-defense and that she was in imminent fear for her life, and that is why she took blank action. Or blank inaction, but an inaction in this scenario does not make sense. He could not literally zip it up by himself, especially when we know that the little handle was broken and that it had a paperclip in it. It is impossible for him to have done that without the assistance of Miss Paulson, or without the full control of Miss Paulson doing it intentionally. You have to prove that act that got him in the suitcase and got him from the top floor to the bottom floor were both self-defense.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic.
It doesn't make any sense whatsoever. It absolutely is circular reasoning. All they're doing is going around and around and around until you give in and stop poking holes in it. He literally just said, we can't prove it was self-defense. It's the state's job to tell us why it wasn't self-defense so that we can say it was self-defense. You're literally saying that unless the state tells you how he was murdered specifically, then you can't assert why it was self-defense. Your client is right there. Look at her right there. Go say, hi, what did you do in self-defense of yourself? What happened? And then she should tell you. But she can't because it's all bull.
And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase, against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have.
More like that's the only lie you can string together based off of the evidence you have, which is why you're hoping the state will give you more so that you can fill in the holes in your lies that make absolutely no sense. Kranick is right. It is your defense, your responsibility to put this up. And that is so wild that you're just like, that's all we can tell. We can only tell that he got zipped up against his will and she didn't let him out, and that was the act. Okay, if that's what you're assuming, then you need to make an argument off of that assumption. Literally just ask your client, why was she in fear for her life? What happened?
But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
Period. And I think I heard about that guy, the Marsha case, that's the guy that they're trying to hire to say the exact same thing, which is bananas. Like, the fear of imminent threat is in the mind of the battered spouse. Yes and absolutely no. Like, yes, as in you can interpret different actions as violent because they've matched the abuse that you have faced in the past, or a trigger just snapped or what have you, and then you can try to say that it's justified because of but you are not asserting that she was in fear of imminent danger. You need to do that. You can't just say, well, she thought in her mind she was in imminent danger. Why? When everything she said was that it was a great day, she doesn't have any marks on her, he didn't do anything against her, he was happy, it was a great night, you just played puzzles, art, painted, and played hide and seek. Where in any of that is she defending herself against anything?
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. And I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
Correct. So that means we're all on the same page, right? That you cannot run this defense until Miss Paulson gets on that stand and lies in front of the jury. Otherwise, you can't use this in your opening statements. That's their whole point, is that you didn't submit this properly. You didn't provide any evidence that says this is why we're going with this defense. In all of these other cases, when there's either a shooting, a stabbing, something that's quick, there is a weapon or an object involved that was used against the victim, which resulted in their death. It was an act of retaliatory act of defense in some nature or another. This happened and then this happened. There is no cause and effect here. You're not telling us there is. You're not telling us there was a fight and he crouched in the suitcase and said, zip me up as a joke, ha ha ha, and then you wouldn't let him out. You keep pointing the finger at the state, saying them, when we are talking about you and your theory of the case. Whatever the state thinks is true does not matter. You were given enough information, which is she was charged with second-degree murder due to these 2 videos of her filming herself taunting and laughing at him, admitting that it is her on the recording, that she acknowledges he's in a dangerous and cannot breathe state, and does nothing. And not only does nothing, taunts and keeps poking at him until she leaves him there. You are the one who needs to say, they don't know what happened before or after. We will prove what happened because boom, boom, boom. Or you need to just say, Sarah Boone will get on the stand and testify, so once she testifies, we will be ready to run this defense. You want it both ways and all the ways. You want the state to tell you how to run the defense, and then you want the judge to let you run it any way you want. No. This has to make sense, and it doesn't.
That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Oh! Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
What is the tea? The girls are fighting. No! The girls are fighting. Why?
The girls are fighting. I don't think I've ever seen Kranick this upset. I'm loving it. I'm hoping I see this at trial. I mean, I know we won't, but I'm hoping he will get them in check when he needs to get them in check. Now, however, even though you are a legal love of mine, Judge Kranick, you are wrong in this case. He did bring it up in the past, like a few little bit ago. It wasn't clear. It's never been clear. He's really only truly asserting it right here, right now.
Then what are you claiming?
Self-defense.
So yeah, he did mention it, but I would like to validate your emotions, Judge Kranick, and to say that I understand this reaction. I empathize with this reaction. This is frustrating. It is confusing. It is not logically consistent, and you're having to unravel a whole bunch of mess. I know he's sitting there being like, this sounds like I'm talking with Miss Paulson right now. This sounds like what we did these past hearings without you here, talking in circle again and again and again, waiting for you to get to a point, which he still has yet to clearly establish. It is all the pointing the fingers, all in the air, all the, I can't do this because of X, I can't do this because of Y. What can you do? What can you say? But yeah, you should have said self-defense multiple times before then, because when he's bringing up all of these cases, when he's saying a gun was used here, when he's saying appeals courts ruled this way or that way, you needed to keep saying this case is also self-defense because blank, and you won't tell us what the blank is. You refuse to.
For the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay.
Good for you for not fighting back and just reiterating it, because a pettier lawyer would have just gone at it, said, yes, I did say that, but good for you. Now we can move on.
Not accident, as they want to allege.
As they want? Not accident as they want? That was Sarah's whole story to this date, except for maybe 2 to 3 weeks ago. Sarah has done nothing but say it's an accident. The state didn't say it's an accident. The state knows it wasn't an accident. The state is saying that you are saying it's an accident because that's what the defense has been saying for years. So don't, again, you trying to point the fingers of it's not what they want. Did they force her to say these things? Let's see. Let's see in this clip, at what point did the state or law enforcement force her to say it was an accident?
My plan was not to go upstairs and go to sleep.
Well, that's what you did.
Yeah.
But not intentional. My intention was not to leave him in there. My intention was not to leave him in there.
He's asking to come out.
I didn't do it intentionally. That was not my intention. But my intention was not for this to happen. It was not intentional. It was not intentional. Not intentional. I didn't intentionally go to bed because this was not in any way, shape, or form, hand on the Bible, intentional. No,
that's absolutely what happened.
Intentionally. I didn't intentionally mean for this to happen. So you guys think that I intentionally didn't do it. That I intentionally did not do. Not intentionally. Not intentionally. Not intentionally kill him. I didn't do that intentionally. I did not intentionally do this. But my intent was not for that to happen. But you think that I did that intentionally. You think that I did that intentionally and not intentionally to leave him there. Or intentional. In no way, shape, or form was this intentional. Because now you all think that I had even more, in quotes, intent to do what I did then, which was not intentional. I'm being accused of something that was not intentional. I'm not admitting anything about being intentional and I killed George. My intent. It was not intentional. I promise you, on life, it was not intentional, which I swore on my son's life was not intentional. That was not my intent. That's my intention. What, that it wasn't intentional? Yes, but it was not intentional. Not intentionally. We understand that.
She's still dead. I didn't do it.
Intentionally. Not intentional.
Okay.
This was not my intention.
You were trying to figure out what's going on. We're still trying to figure out what's going on.
Unintentionally.
So did the state make her swear on her son's life? No. She swore right 100% hand to God, and I swore on my son's life. She said it twice. So you swore to God and your son's life twice, and that was a lie? How can we believe anything you say? You tapped in to the highest things you can. You said a higher power, I would tell God I didn't do it. I would let you in the life of my son, telling you I didn't do this intentionally. 4 years later, it's intentional. Screw that kid.
Girl, fuck them kids and fuck you too.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us?
Oh, so this is Mr. Henderson. This is the third charmed one who joined this ragtag motley crew, driving their careers into the mud. I want more from you, Mr. Henderson. But I do like that suit, I will say that.
If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because
Oh my gosh, this hurts my ears so much. This is a nightmare. It sounds like those horrible recorder memes.
getting reverb from you.
Okay, this is rough. So we're just going to speed through until they actually start speaking. But wow, I hope he is not speaking for a lot because I don't think I can handle this.
Mr. Henderson, we'll give this a shot, sir. You can go ahead.
Yes, sir. Can you hear me now?
I can, sir.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge. I'd like to respond. And first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is that it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all.
Well, I will try to summarize this where I can, but basically he is just saying you don't have to have a notice or a statement of particulars to run self-defense, which is true. However, you are running self-defense by way of battered spouse, and for that, you do need to have a statement. You do need to let people know ahead of time what kind of specific self-defense you are using.
Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they would perceive an imminent danger different than someone else.
At least he's explaining this better than Mr. Owens. Like, good Lord. He made it very clear that battered spouse syndrome is not a defense in itself. The defense is self-defense by way of battered spouse. And the way that comes in is in the jury instruction. They will say that due to battered spouse syndrome, when you're thinking about the elements of the crime and second-degree murder, and when you look towards self-defense and that imminent fear of danger, that is where battered spouse comes in. So the perception in their mind that they were in imminent fear of danger resulted in this action because of the sustained abuse that they had throughout their relationship. So it's not saying that battered spouse is a defense in of itself, but they are arguing that they can put this evidence out there so that they can get a jury instruction at the end that upholds that as viable when analyzing the elements involved in the charge. And jury instructions are pivotal. Cases are won and lost on jury instructions because that literally instructs the jury on how to analyze the evidence, how to read the evidence, and what to consider, what not to consider. A jury instruction that I keep hitting, because I guess we're just using the Depp Heard trial this whole video. Why not? But one of the jury instructions, and it's pretty common, which is if you found that a witness has lied, then you can disregard their entire testimony. Meaning if you believe that they told one lie on that stand, you can throw it all out. And when the jurors came forward, the jurors admit that they threw out both Amber Heard and Johnny's testimony, anyone who was in the family, and any hired expert. The only testimonies they took into account were the third party, police officers and other people who did not have a personal stake involved. And they can do that because the jury instruction allowed for that. And that's why we got the result we got.
Because what the self-defense instruction required is that the jury place themselves in the position of the defendant. In those circumstances, at that point, battered spouse was to help explain those circumstances. So the first instruction that you have to get before you can even start talking about battered spouse is this. You have to get the self-defense instruction. So, and that will be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense, this is self-defense, there's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense.
Yeah, so we should all be on the same page. We all agree that testimony must be given before you can run this defense or this argument. However, you don't think that Miss Paulson should have to be the one to testify. You think that only Dr. Julie Harper and the other expert witnesses should be the only ones that need to testify in order to give that instruction. No. In my opinion, no. I need her up there to establish all of these lies, and then you can have all these forensic experts come in afterwards and to explain them away. For some reason, they really don't want to do that. They really don't want to even allude to the fact that she might be getting on the stand. She will be, though.
When a battered spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify. So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time.
Are you sure you're not the prosecutor right now? Because you're making those same arguments that she needs to testify, she needs to establish these facts, she needs to have evidence that it was self-defense, and then you can have the experts come up. That's all we want. Really, that's all the state wanted. All the state wanted was you to, one, submit this properly. They're not just going to ignore it if you submit it improperly, especially for a publicized case. Because if they just let that slide, then if I'm a lawyer who's in that courtroom, I am bringing this up all the time. Well, you let this slide. You let this slide. You gave them special treatment. So why can't I just half-ass it? And then the other issue was you only had one witness to establish all of this. So they're fighting against the state's motion to strike, saying it's unfair when they only submitted one witness and said, we want to run this defense. They didn't give evidence. Even in the statement of particulars, they didn't show evidence. They didn't go to specific dates. They didn't go to medical records. They didn't go to any of that. In their amended motions, you know, it was a little better when they added a few more witnesses, but it's still lacking. And if they had more time, they absolutely probably could have done a really good job with their opening notice. So I get that. However.
Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that are there, this is what I watched, this is where it came from, this was the interviews, this was reviewing other type of data and other types of things, and preparing their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about in the jury instruction is this is something in the back of the report. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we have at the beginning here, when we start talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was accident, and that's it. And I really put it. No one was even the ruling of that. That was the testimony. In this case, we do not have testimony.
They're saying they haven't gone against Wagner because she hasn't testified that it was an accident yet. But she gave nothing but sworn statements under oath that it was an accident. And that's where we have that impasse. So this is the first time y'all have ever claimed self-defense. So you're basically saying we need to wait until trial and whatever testimony comes out, then you can try to strike it or what have you. Because it's a jury instruction, we don't need to strike it ahead of time. Wait until we mess up in trial, then try to do it. And I get that. And that's probably what's going to happen.
What we have evidence to say in this case, saying the discovery in this case don't do it. But that's not trial evidence. These women have to know better on the testimony of the report, either testimony itself, physical evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
Thank goodness you cut in. My ears hurt. I'm so sorry if your ears hurt as well, but this is wild. He's doing a good job, but why can't people ever figure out technology? Like, y'all got law practices. Figure out how to use Zoom. And you're all in Florida, so it's not like you're working against time zones or working against extremely long distances. I might just let this play as long as I can unless something major comes up, because we have to get through this. It's too much. And I'll summarize big points or something that really pops out to me. But yeah, whew.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end.
Okay, yeah, last thing. I can't imagine how difficult this is for the court stenographer right now, trying to keep up with this mess.
You seem to be projecting away from where your microphone is.
Okay. There's my problem with me, but it might be the room better. Can you hear me better now?
Madam Court Reporter. We will do our best, sir. Keep going.
Yeah. So, to break a little report landing, Judge, is simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make a decision if justify the use of non-deadly or justify the use of deadly force is appropriate to give, and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about battered spouse. Now, if you don't get the expert to talk about battered spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument and that decision can only be made after the evidence is put in that trial. And that's all I have, Judge. Thank you.
Oh, thank God. Oh my gosh. I didn't know what was going to happen. I was losing hope in humanity. My ears were shattering. But yeah, good job, Mr. Henderson. You did what you needed to do. Your argument was basically, yes, the state is correct about what they're saying. However, we should not strike this. Since it's a jury instruction at the very end, we should not strike it until we get to trial and wait for us to mess up there. But this is too soon now. So at least that makes more sense than anything Mr. Owens has said today, in my mind.
Mr. J, any response?
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay.
And that's a good delineation, because the defense is trying to use this argument to say she thought she was in imminent danger. She thought this in her subjective interpretation, when you're using battered spouse to prove an objective perspective, saying, I know this seems unreasonable to you on the surface, but now that you've seen what battered spouse is, does it make more sense for an objective person under those circumstances to be in fear for their life constantly? So if you are someone who is assaulted and abused daily, you can't get out, you've tried to get help, and you are trapped. Under those circumstances, now that the jury understands that, would they be able to say an objective person in that situation could respond this way? And in certain situations, you can see that. You can see that, oh, this looks terrible on the surface, but the reality they lived in was hell every day. And if any objective, reasonable person was in that same scenario, we might all have considered that in order to escape our abuser. They want to say, because of the abuse in her mind, she thought she was being attacked at all times. So even when he's in the suitcase begging for help, she still thinks she's in danger for her life, and that's why she didn't open it. Not how that works.
With that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense, in particular was, did this violence cause her to suffer from battered spouse syndrome, and what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then like everybody else, we were playing hide and seek, and he got into the suitcase, and I accidentally went to sleep.
Exactly. You better read her down. when he said, and like everyone else, we played hide and seek to show how absurd that is. Like, no, not like everybody else. What adult does that after drinking all night, doing puzzles, doing artwork? I'm sure there's some out there that is not common. And he knows that. I like that little jab at there. Yeah, she said it was a great night the entire time. That's all she's ever said. And I've put so many clips in there throughout this video of her doing that. And there's still more. I could not fit all the times that she has said it was a good day. But I'll try.
Everything was fine and dandy. Everything
fine and dandy.
was fine and dandy. We had a good day. It was a good day. We've had good days lately. It's been good. Like, I don't even know where this is coming from. So happy. Like, it was such a good day. I kid you not. He and I having a great day, fooling around and being stupid, but I would never do that.
But it happened, and you did.
But that's after being playful.
But no one's
And
laughing.
having a good day.
No one's laughing except you.
Everybody's having a good day. Oh, I'm sorry?
I would hate to see a bad day. The lasting matter.
It was fun.
Not by that
All
video.
day. All
By
day.
that video, that
All
part
day.
wasn't.
It was a great day.
Okay.
It didn't end well.
And then she's shown her video, but her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night.
Yeah, and what he means by testimony by narrative is what happened in the Robert Tullis case. I haven't really looked into it. I saw like 5 minutes of it. But it's when lawyers can't ask you questions if they know you're going to lie. So if she wants to testify and it completely contradicts what she said earlier, and it is known she is lying up there, she has to testify on her own. The lawyer can't ask her any questions. She will still get cross-examined, but she will be up there on her own telling her story. Because if she doesn't, that means the lawyers know that she is going to lie about these answers and would be unethical. So he's already stamping that out. If she's going to completely change her story now, she has to get up there and say it on her own.
And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to this?
Oh, Kranick looks stressed. It's been a long hearing, and I get it. This has been a lot. But you're almost through. Push through. We got this. We got this. Low-key, I'm telling that to myself because this is my longest video yet. I cannot believe. But with all the inserts and with all the talking, I guess all of my videos are going to get humongously long now. But goodness, we got this. We got this.
State's argument, either Mr. Owens or Mr. Henderson.
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
That comment was unnecessary. And no, that's not what jury trials are for. Jury trials aren't for you to figure out your defense in the moment. It is for you to come with particulars beforehand. He just asked you to lay out how this fits this defense or this strategy, what have you. And you won't do it. You're just saying, wait till trial, wait till trial, wait till trial. Fine.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge.
No, God! No, God, please, no! 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 No!
The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address. But, yeah, I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Oh! Judge, and as you know, we came in late.
We know!
I know! You know, I know. I got it. I got the concept.
Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him.
Oh, Brandon is a critical witness. Brandon was one of the 2 roommates, but then why aren't you calling Vincent? You're calling Brandon because Brandon said that George was a very bad guy. You know what else Brandon said? He said he only talked to Sarah and that he never actually talked to George. So of course, if you only talk to Sarah, you're going to think he's the worst human who's ever lived. So they're going to call that up and say, didn't you say this? He's going to be like, yeah, he's a bad guy. And then the state is going to say, how many times did you talk to George? Not one time. But okay, he also didn't like Sarah. He just had one comment that was in her favor. He talked about so many times how he would try to avoid her and just end conversations with her, and that it was just a cringe time all around. But I guess he's crucial.
No way. I want to see the receipts.
Do you know either of them? Like, do you know?
I've had a few brief interactions with them. I haven't interacted with him much. I've spoken to her a few times.
You've spoken to her a few times. Okay. How do they appear to you?
They almost always seem either like tired or like tweaked out.
And any other interactions with her?
No. Honestly, from the few times I had spoken to her, like anytime I saw her, I kind of just tried to go straight into my apartment.
Right.
There's a few times where I would walk past and she'd say hi or something, and I was just kind of lie and be like, oh, I'm only going to be here for like 10 minutes. I just got to change and head back to class or something. Like, I tried to avoid.
Mm-hmm.
He was a bad guy. He was a bad guy.
Mm-hmm.
So they think he is a crucial witness. But his roommate also counteracts that, or I mean, it supports it. But his roommate actually spoke to both of them and still places Sarah as the more aggressive, over-the-top one. So if you bring Brandon up, one, it's not going to be good for you. It doesn't seem like he has many good things to say. But if you can hook onto that one sentence, then they can cross-examine him and bring his roommate up. I mean, they're going to bring his roommate up anyway. But two people lived in the same house right next to them. One of them talked to both of them. One of them only talked to one.
As you know, 4.5 years, people move, so we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days.
Which you're extracting again. You have it. You're going to make that sound like you're holding that up. You're wasting your own time doing that again. Instead of going to the state saying, hey, you handed this to us twice. Can you make sure I can open this? Help me open this right now. Instead of doing that, you want to have a whole new imaging. Hire the expert. Get them paid for by the JSC. Schedule times. Get them to run the analysis. Get the report. Analyze the report. Then you can finally do something with it. And by that point, you probably have 3 days to trial left.
And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we...
No, that Freudian slip was correct. You are relying on the insanity defense because it is insane to think that this defense will fly.
find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial.
And
She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time, The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years.
Damn, he is going in. He's absolutely right. They want to wait until trial to keep changing things again and again. No, I have no problem with extending time a little bit, but when you get that close to trial, you need to be ready to go. And by extending the time, I don't mean extending the trial. I mean extending times you can still file some things and move things around. But yes, this is not the trial of Mr. James Owens. This is the trial of Sarah Catherine Paulson, the artist formerly known as Miss Boone Esquire. This is her trial, which she knew about for over 4.5 years. How do we know she knew about it? Because she nonstop talked about it. They had all this time. All the time she was sitting on that bunk in that open bay dorm, she could have been thinking about her self-defense argument. She could have asked her lawyers to go that way. Oh, wait, her lawyers did want to go that way, and she fought against them every time. Now, when you finally give in and say, this is my best bet, you want everyone to pause and give you all the allowances in the world to run a failing defense.
And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
And while he's taking a moment, we can just, I am glad that it's finally done. But the idea that the state might ask for a continuance blows my mind. I hope not more than anything. But if they keep granting these extensions and allow the defense to move things around, the state is completely entitled to a continuance in order to adjust to that. And it would be granted. Also, there's our good old faithful shady cameraman zooming right in on those split ends.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
just so that you understand, I've ordered a couple hundred people for that week.
Whoa, a couple hundred? That is wild. Normally you have, 30 to 50, something around that number, but hundreds of people to try to go through. And that's good. That's good because, she's going to rip through them and say, you can't do this, you can't do that. You don't know this, you don't know that. Strike, 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 strike. So he wants to make sure he has enough people to where we are getting a jury. We will have people. We will vet them as much as we can. You can ask all the questions. There will be bodies in here. We are picking a jury. And that looks great for the record. Even more special treatment of we made sure to get you a jury that you were happy with. So we brought in hundreds of people. So you can't say that the jury was biased or bad or this or that, when you will have gone through hundreds of people and narrowed down to the jury that you and the prosecution agree on?
Because I don't know how long jury selection is going to take. I don't know what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting y'all, full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30, and that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous.
Yeah, I don't see that happening. Especially when, as soon as you start picking stuff up and getting people here and getting people there, and you're like, oh, we think we almost have it. Here comes Miss Paulson, hand raised. I don't like that person. No, you got to get rid of that. No, you got to get rid of that. I know she's going to have a lot to say about jury selection, which is why I am so glad she's not doing it on her own. That would have been literally a whole week process, would have been a nightmare. And while she won't be doing the talking, I'm sure on any little court break or anything like that, she will have her hand raised. She will be telling them this. She will be telling them that.
But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So,
and why is that? Why did none of the prior experts give a diagnosis or an opinion about battered spouse syndrome? You're using Mr. Padilla's playbook, so actually he did. That's when Dr. Julie Harper got on the first time. So I guess she was ready to go because he was ready to go. They were 2 weeks away from trial. Oh, wow, this is crazy. You are in the exact spot where Mr. Padilla was last time before he pulled out because the adversarial relationship had become too much. She didn't agree with him. She said he wanted her to say things that were not true, did not happen, and she did not agree with.
We started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that, I agree with the court, but I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had...
Oh yay, Zordon's back. He's a fun recurring character here. I appreciate him.
provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rating in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's just that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor.
I wonder if this is the court's issue or just everyone has horrible internet access and doesn't understand computers whatsoever. I'm more inclined to think it's the court now because I don't think we have ever had someone zoom in and it didn't sound like nails on a chalkboard.
We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert that's being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the Battered Spouse Syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed rates for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense, but that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, you know, that the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc-pro-tunc, because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
Honestly, this is so boring right now. I'm just gonna let this play until it gets interesting.
September?
Yeah, is that not what I just said? I'm sorry if I said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
Oh, we're moving on. Great. Okay, cool. Please let these be quick. Please, Mr. Owens. I don't want to be here much longer.
This relates to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand-filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
Okay, he likes to move around and do this and do that. Although that's not like the best public speaking protocol of just wandering around unless you have very intentional movements of, I need to go over here to get your attention, and I'm separating my points out by transition walks, which is fine. But if he's just going to be swaying back and forth, aimlessly pacing around, that is very easy for an audience, or in this case, a jury, to zone out in. But who knows? Maybe he's engaging.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to file something?
Get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing.
Yeah, we already did this. We already had Skirt Gate, where she wanted to wear the skirt and the ankle cuff, but be like, well, I thought you said you can move it up. No, you didn't. You just want what you want when you want it. And this is another thing. I remember, I think it was Miss Click was her name. She said they have like 8 pants, 3 skirts, and a dress or something like that. And she still wanted to wear the skirt. Why are we bringing this up again? She even said then that you could have a friend come by and drop you off stuff. So why do you need Mr. Owens to bring up the street clothes again? This is crazy to me. I can't imagine how their interactions are when they have their meetings. Because that just means she brought this up again and again and again. And the thing is, what I will say, all of her other lawyers didn't bring up this miscellaneous request that didn't really mean anything. But he is bringing up every little request that she has. And you kind of can tell what she is directing him to say and the arguments that he actually wants to make. The street clothes things, we all know they wear street clothes. Almost very, very rarely, unless they reject the offer and would like to stay in their prison uniform, which some people do because they think that it reverse psychology when they think they're being mistreated and want the jury to say, look at them, they shouldn't be there, or something like that. Whatever. But you are going to be in street clothes. You knew this. Why are we doing this again? And I know there's more complaints.
Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
We have gone through the entire clothing closet as well as our backup for what we have. As it stands right now, unless we have any donations in the student size that have to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, well, we do have some shirts, but in terms of skirts versus pants versus the dress, that is everything we have that would fit in this student size range.
I can't always have someone externally bring something into me.
Absolutely, you can always have someone provide something in your personal property and,
Yes, ma'am, thank you.
All right, any other questions for her? All right, can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am.
So just another instance where she has re-asked the same question that she already got answered and they already gave her what she wanted. Either they have those options or you're allowed to let people bring you things from your personal possessions. But that wasn't good enough because it's not the answer that she wants. So she's making someone else ask again. She is relentless. I could not imagine being around her at all ever. Like, my gosh, is she exhausting.
Before you came on board, Mr. Owens, Barry Click, Barrieclick, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
What? What is even happening now? It's one thing to wear street clothes during the trial. I get it, because the purpose is you do not want the jury to have the inference that you have already been convicted. Because just because you're on trial doesn't mean that you're in jail. And when you are in jail and wearing jail uniform, then they think the conviction has already happened, and that already, influences or shapes their own perception. And that's the only reason you're allowed to wear street clothes. It's to give you an equal, fair shot with as little unforeseen bias as possible. Not at a regular hearing where there's nothing here. I mean, the only thing is there'll be cameras. And I guess that's why you stapled your pants leg illegally down and they caught you, because you wanted to tailor your pants more. No one is checking about what you wear. We're more focused on that stank face and stank attitude you have. Goodness. She really just asked, can I wear street clothes to hearings? To hearings. She just wants endless special treatment. It is mind-blowing. Ma'am, you murdered someone. I don't care what you want to wear. Stuff like that just makes me so irrationally upset. Again, for the trial, I understand. You want to look good, that's cool. But for the hearings, who do you think you are, honestly? Because I think you think you're important when you aren't. You are an anomaly, and you are a burden on many people, especially the legal system. But that does not make you special. Because what do we do now? What's next? Now everyone's wearing street clothes to hearings. Why? Because this case is so publicized, and the more you just let all of this stuff fly willy-nilly, the more you give and give and give her this and give her that, when it is not material to the case. Whether she wears street clothes or not is not going to change the arguments made in these hearings. But whatever, Mr. Owens, you have been whipped by Sarah. She has you controlled, and you will do anything, and you will ask anything she wants you to.
If you could get it to her. So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair.
I'm sorry, come again? She wants makeup and hair done? Makeup, okay, whatever. Just get some jailhouse makeup. I don't know, put some Kool-Aid in some water, get you a cute little lip tint. Are you hair? I'm sorry, I have to walk away for a second. This is absolutely absurd. She has no self-awareness, no humility, nothing. She has no shame whatsoever. She will ask for anything and everything relentlessly. She wants someone to do her hair. I mean, if I had those Edward Scissorhands chop and screw bangs and that bird's nest in the back of my head, I too might ask for this. However, I would have enough awareness to understand maybe this isn't the time. Maybe not in open court. You are literally asking the judge to pay for someone to come do your hair. Do you not have friends? You said you had friends in jail. You can't find someone who does hair in there? I don't believe it. I don't believe it. I mean, someone had to cut the hair the way it is now. I mean, to be fair, I would not trust the same person who gave you that haircut to do my hair for trial. So I get that, but get the F over it. She infuriates me to no end with these antics. It's so dumb. It's so stupid. It's so useless. And it's only for her feelings. It's not going to help anything. It's not going to make the jury like her more. It's not going to make it easier for your lawyers. They're going to have to wait there because you're going to hound them to make sure everything goes smoothly. Then you're going to complain at the hairstylist saying, oh, I don't like this. Oh, I don't like that. Or this makeup is bad. How am I supposed to go out there with this and with that? Oh, everyone hates me. You did this on purpose. It will never end. Why? She has a proven track record of this exact behavior. You give her what she wants, she doesn't like it, and so she complains and wants more. Oh my God. Makeup and hair. You know what? You can go to Claire's, get her that little baby makeup with a 2-inch mirror and say, have fun. Have at it. Either that or go 0 to 100. Fly in a drag queen. Fly in a drag queen and put on a full beat. I'm talking baking. I'm talking cut crease. I'm talking overdrawn lips. I'm talking blocked eyebrows. I'm talking high arch. I'm talking contour. I'm talking lip liner. I'm trying to remember every makeup term I can figure right now. I'm talking foundation. I'm talking concealer under the eyes to conceal the lies. Oop, bars. And I want to see it blended into the neck, okay? If you're going to do that, I want her up there, and the drag queen can do the hair as well. Put her in this big, over-the-top, I want to see this 310 ombre bust-down wig install, laid edges, face taped, and then put her on the stand, have her turn to the jury and say, does this look like the face of a murderer? Oh, wow. Wow. She's the joke that keeps on giving. Wow. Makeup and hair. Makeup and hair. Or better yet, have Tyler Perry come in and do her wigs.
In a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Joe.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
Wow. And there it is. We finally made it through. This is officially my longest video yet. Why do they keep getting longer and longer? I think it's the receipts. The receipts are making it longer now. But wow. Oh, side comment real quick. Miss Banana Clip right here, the black hair Miss Banana Clip with the sharp shoulders, she is giving. She has been giving this entire, I mean, the tailored suit, the shoulder pads, the updo, the two sides, the glasses. It's everything. This is the look of that girl. I would prefer she be my lawyer, honestly, but wow, she has a whole team. She has a whole team, and they struggle to get through this hearing. I struggle to get through this hearing too. It's a lot. But the best thing is, I didn't have to hear Miss Paulson's voice this entire time. Even when she was being sworn in, I couldn't hear it. Low-key, I hope those handcuffs are a little bit uncomfortable. And I do want to make it clear, I don't support nor condone sending any hatred towards Miss Paulson or anyone affiliated with her whatsoever. I am a hater, just as a human, like I am a hater, that's it. But I do not hate her, if that makes sense. So make sure that we're, still being kind enough as a person. We're not like doing too much. She is annoying. We are allowed to be annoyed. We can critique it all we want. I have no issue with people making fun of her because, I mean, she is a schmurderer. So yeah, this was the September 19th hearing. Whoa, was it a doozy? But it is official. This was not on accident. Miss Paulson has now admitted, you can still kind of see a half smile here, that she did it on purpose. Oh, and it's a skirt suit. I thought it was a pantsuit. Sorry, I am distracted by her. She is gorgeous. Moving on. She did it on purpose. She took Jorge Torres' life intentionally. We all know she did, but now she is officially admitting that. She's still pointing the finger and saying that it wasn't her, just like she did with all the other instances when the police showed up and say, hey, why has he scratched the F up? I don't know. I was just fighting back. I was being honest with you. I don't believe a thing that's come out of her mouth, honestly. I have no clue what happened that night. The more you look into it, the more theories you look into it, and you find out more and more and more, the less sure you become about everything. The evidence is the evidence, but all the stories are thrown out the window when you hear more and more things show up. I mean, originally I thought that it was a laughing and fun-filled night, that she tricked him into the suitcase somehow, because as she drinks, she gets angrier and angrier. So it could have been this fun time that then turned sour, and she decided to flip on a dime and then decided to become cruel and evil. But then we heard from the witness interviews that they were yelling starting at 7:30 at night. It was not a happy night. They were yelling and arguing all night. The neighbor Vincent said he heard them say, I hate you, I hate you, I hate you, so many times. So I don't know what is happening anymore. I can't wait for trial so that they finally string all of this together. And she can't hide behind these same weak lies anymore. I'm glad that it is starting to catch up with her as we're getting closer and closer, and it looks like we are going to go there. But yeah, it looks like we have 19, 18 days, or I guess when this gets out, they have like 17 days left, 17, 16 days left. 2 weeks, basically, a little over 2 weeks, and we are going. By all the feelings I'm getting, Kranick is going to keep pushing this. He wants this done, and he wants to move forward. So yeah, there's that. This video took way longer than I wanted it to, and I am just going to post this right out. I'm sorry, this isn't going to have a members only early post, because one, it's going to take probably an hour for this to export and an hour for this to upload. And by that time, we'd all be up till midnight. So I do want, and people got work in the morning. Kids got school in the morning, people got work in the morning. I want you to clean your house. I want you to get ready. I want you to tuck yourself in bed, get a nice meal. I hope you had a good drink, you had a good snack, you had a good laugh, all that good stuff. So I'm going to release this as soon as I finish it. Thank you all again for the support. I always appreciate it. I hope you all really enjoy this video. I worked really hard on it, so please support it if you liked it, if you enjoyed. Let me know in the comments below. And with that, don't forget to like, comment, subscribe, dislike if you're feeling it. Until next time.
Thank you all for watching this here video. Please like and subscribe.